Out. Excuse me, court officer. Court officer. ಏನಿಲ್ಲ ಸರ್, ಆಡಿಯೋ ಕೇಳಿಸ್ತಿಲ್ಲ. Now it's clear.
ಕೇಳಿಸಿದ್ಯಾ?
ಕೇಳಿಸ್ತಿದೆ ಸರ್, ಕೇಳಿಸ್ತಿದೆ.
ಆಯ್ತು. board branch. Huh? Fresh matters. Please give. Give. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಕೊಡಿ give it.
AGM is on 16, and the respondent is apparent that they may not be permitted to attend the AGM. So the matter may be listed for more minutes. It is on 16.
AGM?
AGM annual voting meeting is on 16. And the respondent is apparent that they may not be permitted to attend the meeting.
Why?
They filed necessary applications.
Why?
There is a dispute with that. I mean, there are members of the society.
You can't file a writ petition for that one, sir.
No,
Give it, will let us.
More applications filed.
You please give it, we'll see. What do you want? What? Which matter? Fresh matter. So please give it then. ಕೊಡಿ ಕೊಡಿ ಆಗಲ್ಲ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಎಸ್ ಆಗೋದಿಲ್ಲ ಐ ಹ್ಯಾವ್ ಗಾಟ್ ಸೋ ಮೆನಿ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ವೇಟಿಂಗ್ ಟುಡೇ number 11. The petitioner and learned counsel for petitioner have filed a memo dated 6/7/2023 stating that the matter has become infructuous and therefore the petitioner may be permitted to withdraw the writ petition. Next paragraph. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition can dismiss as withdrawn.
Number one, number one. If you have
At AGA, take notice for response number 1, 2, and 5. Learned counsel Shri TL Kiran Kumar is requested to take notice for response number 4. Issue emergent notice to respond number 3. Learned counsel for petitioner is directed to serve 6 of copies of the petition along with the annexures on learned counsel for respond number 4. The copy and the learned AGA. Similar orders. Nanne yavudu nanne number 19998 of 2023. Dated 11/7/2023.
number two. Sanjay Kumar.
Huh? Huh. What is the award amount? Huh? Where do you find that? You have not given any information except this notice. Huh? Not what was borrowed, sir. What is the award amount? Award is passed for what amount? Without any information, if you come like this, no use. It depends on what is the award amount. Then we can ask you to deposit a certain sum of money. No information is here. Correct, sir. It's not 20 lakhs. 20 lakhs you have borrowed. What was the award amount? Issue emergent notice to the respondent. Returnable by 26th of July.
Serial number 4, my lord.
3.
Serial number 3.
Second respondent will raise. Second respondent. Second petitioner.
On 29/5/2023, they appointed a returning officer. But the returning officer was dates up to 21 days. On 19th day, letter telling that as pre-occupied the bar, I cannot go ahead with the election. Kind substance from our officer on 8/23. Thereafter, once we approve this honorable, put what by direction, conduct election, of the post of the president. But you are watching more impacted part of order. Some of the authorities must to the explanation must and to also conduct the election of the post of the president.
Matter pending.
That is pending. But now what happened? Subsequent to also part of 2023. But they fixed the date not by appointing a new officer. Conduct an election was on 6/7/2023. But what happened on 6/7/2023? Put 1 hour prior to the election. But these assessment are not they have got some 2 orders against the second petitioner and the third petitioner. Passing an interim order under section 71 clause 3, restraining them from participating in the election. The prior 1 hour without any notice, without any hearing opportunity to the petitioner. But this is a modified or arbitrary action of the part of the authority. But because they don't have majority in respect of the ruling party, they want to elect. They unnecessarily they are postponing this election.
Cooperative society is the ruling party.
How majority?
ruling party.
particular.
Where the question of ruling parties are in cooperative societies, what submissions are you making?
This is the fact what we are facing.
Unnecessarily,
this is arbitrary action and malafide action on the part of the authorities. But section 70, they couldn't have invoked because pertaining to election, put the limitation is only 30 days. And even not under section 89 also, there is no provision for them to grant interim order. Not unnecessary, not without any justification. One of the other reasons they don't want to the post the president election. Not in fact, I made some.
What is the prayer in the petition?
To conduct the elections, not to return the other, not to.
How many times do you want to file repetitions like this? That repetition is still pending.
Not that petition was to conduct the election.
Yes.
Subsequent to that, not that the order, not observation, they wanted to conduct the election.
Yes.
But not indirectly, not
They have not conducted.
Indirectly, they are passing the order. Disqualifying or interim order.
That is a different cause of action.
Therefore, not I filed the petition.
It is for disqualification order is passed against whom?
Not it's not order of disqualification. The order is not against the petition number 2 and 3. Not restraining them from participating in the election. What happens from one to four and the election will not take place.
Only they can question it.
They are in fact they are filing petition. They are also the petition.
Can't go on filing petitions after petitions like this.
Now what happens? The orders passed, not the interim orders passed by the.
This matter along with WP number 13009 of 2023. Yes.
Please, my lord, the last kindly, my lord, serial number 4, my lord. I appear for counsel KL Srinivas, my lord. Kindly pass over, my lord.
ಅದರಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ? Come up with it. Yes. What is this matter about?
Property. The standard one was paid by the Gram Panchayat without issuing notice for after my father. The taking advantage of the same name, the petitioners had filed an application to the Gram Panchayat. We changed to their names. But we filed a application for the Naru Panchayat under section 269 for Gram Panchayat.
There is an interim order passed. Is it? What is it?
IFR appearing of the filed or counter.
ಏನ್ರಿ ಇದು 2023 ಮ್ಯಾಟರ್ ಅರ್ಲಿ ಹಿಯರಿಂಗ್?
Kindly proxy, my lord, kindly pass over, my lord.
It has already come up for preliminary hearing once.
ಒಂದು notice ಆಗಿ ನಾವು ಕೌಂಟರ್ ಆಗಿದೆ. We heard.
This matter next week.
Please, my lord.
The petitioner is a complainant or owner of property? Complainant. You are appearing for the ಏನಂತಿದೆ ಈಗ? Provisional order. Provisional order is passed.
Yes.
Not now. Only after the confirmation order is passed, you can challenge it. Purple. You have to give an answer to this. Along with this, they will issue a notice. So you will have to explain. The petitioners had made complaints to the respondent officers of the BBMP regarding the unauthorized construction at the hands of response number 5 and 6, in the neighboring. The prayer in the petition is to direct the respondent authorities to remove the unauthorized construction or deviated portion. Stop. During the course of these proceedings, the respondent officers were directed to inspect the property and submit a report. Stop. Then a counsel for the respondent BBMP submits that a report of the respondent assistant director of town planning, East Zone, BBMP has been filed on 6th of July 2023. Along with the report, copy of a provisional order passed under section 248(1). That is not provisional order, it's a notice 248(2) calculated. Under section 248(1) has been passed on 23rd of June 2023. Stop. Following the provisional order, a notice under section 248(2) dated 23rd of June 2023 is also issued to the contesting respondents here. Stop. Next para. Learned counsel for the contesting response number 5 and 6 submits that the contesting respondents may be permitted to raise their objection and contest the matter. Stop. Next para. In view of the subsequent developments and the fact that action has been initiated by the respondent authorities against response number 5 and 6 by issuing a provisional order and a notice under section 248(2) of the Act, the prayer made in the petition has become infructuous. Stop. Next para. The petition is accordingly disposed of while directing the court respondent assistant director of town planning, East Zone, BBMP to issue to hear respondents number 5 and 6 and thereafter proceed in accordance with law. Stop. The entire exercise shall be completed as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Ordered accordingly.
Number 6. JP Darshan. Arbitration clause.
Agreement of year 2014.
Yes. Notice is issued at page 41. But the Honorable Court has raised a criminal issue.
Yes.
Notice.
Yes.
Ordinary bench was a referred to judgment for the issues of notice. Page number 23 of paragraph number 19. This is what describes the period during the agreement requires to be performed. The vendor, page 23,
Para?
page 23, para 19.
vendor and purchaser are mutually agreed that all that is required to perform this agreement of such a perform the same month from the date of execution of the agreement. Therefore, same shall be excluded the vendor of the vendor by the amendment of the purchaser or not within 6 months the rate of fulfillment of the conditions referred to herein. And vendors making of a clear market and conversion of the property of to residential use. Conversion has not yet happened, but the view taken by the Honorable Supreme Court is wherever the calendar date is not mentioned, then it is the date of actual refusal, knowledge of actual refusal, which has to be taken under second part of Article 54 of the Limitation Act. That is taken by the three judges from the text.
Let us see.
So, what is the KDC para 11 and 12? I just refer to Article 54 before that. It is at page 465. For specific performance of a contract, 3 years. The date fixed for performance, or if no such date is fixed, then the plaintiff has noticed that the performance is reduced. Then Ramzan and Tarlok since cases were rendered in different factual scenarios, the restrictions do not go on right on the particular hand. According to the advanced law dictionary Ramanatha here, the word date means as a noun, the point of time at which a transaction event takes place, time given or specified, time in some way ascertained and fixed in a deed, that part of deed or writing which expresses the day of the month and year in which it was made. It is said that the primary signification of the word date is not time in the abstract, not time taken absolutely, but as its derivation. And fixed, this is the sense with which the word is commonly used. When we speak the date of a deed, we do not mean the time when it was actually executed, but the time of its execution as given by the deed itself. But then after having expressed this para 11, then para 10, 11 and 12. Fixed is the essence, in essence means having final and crystallized form or character not subject to change or fluctuation. The inevitable conclusion is that expression date fixed for performance in the crystallized motion. This is clear from the fact that the second part, time from fixed period begins to run, refers to a case where no such date is fixed. To put it differently, when the date is fixed, it means there is a definite date fixed for doing a particular act. Even in the second part, stresses on when the plaintiff has noticed that the performance is refused. Here again, there is a definite point of time when the plaintiff notices the refusal. In that sense, both parts refers to definite dates. So there is no question of finding out the intention from other circumstances. Whether the date was fixed or not, if plaintiff had notice of performance is refused and the date thereof is established, with reference to materials and evidence to be brought on record, expression date used in Article 54 of the schedule to the Act definitely suggestive of a specified date in the calendar. So that is the because Tarlok seems case to the reference to the state.
That is not because on this particular point, the Honorable Supreme Court has very clearly stated in BSNL's case.
Yes. BSNL's case also, kindly have a look at BSNL.
When it says 6 months is the period fixed.
Yes.
Your cause of action commences after the expiry of 6 months.
6 months from which date?
From the date of the agreement.
That's further rider in para 23. It is from the date of the agreement, subject to. Kindly have a look at page 23, para 19. It is not unconditional, that it should be done within 6 months.
Yes.
6 months from the date of execution of this agreement of sale, therefore the sale shall be excluded by the vendor purchaser or is nominally within 6 months from the sale. Can you mark the next sentence? Subject to fulfillment of all conditions referred to herein, and the vendors making of a clear marketable type of the scheduled property and the conversion of the scheduled property as a residential use. These three conditions
are ಸೇರಿ 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು.
Subject to, I will put it this way. Subject to means it postpones the event. So that of course, what is meant by subject to an interpretation is to be laid as no difficulty. That's all judgment to the Supreme Court says that wherever a time is fixed subject to, then the time stands postponed subject to the events which are mentioned in that subject. That is the actual meaning for the word.
There has to be an understanding between the parties, and there has to be an extension of the period in writing.
I will just refer to that.
At least by way of a communication.
Yes, in that case.
ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Yes, in that case, you are right. Yes, in that case also. Yes, in that case was a totally different set of circumstances. Where it was a claim for money. born out of a transaction. They raised the invoice. After raising the invoice, whether they raised the dispute under the meaning of section 21 within a period of 3 years or not was the only question. There, the Supreme Court said that once it is a demand is raised for the making of payment in terms of an invoice, then the period of limitation begins to run. Here, kindly have a look at paragraph number 12.
Sir, the entire understanding is if you are precluded from filing a suit,
Yes. But that is emphatically stated. Kindly have a look at paragraph because
if you are unable to file a suit,
but even now I can file a suit.
how can you file a suit?
Kindly have a look at paragraph.
Okay, so we'll have to look into two limitations. One, as to whether the parties will be able to file a suit
Yes.
in the under the general law of limitation. The other limitation is regarding the invocation of the arbitration clause for calling upon the court to appoint an arbitrator under section 11.
Whenever the word subject to is used for performance, how such clause has to be interpreted, number one. But this is an exercise which essentially falls into the domain of the arbitrator under section 16 of the Act. Because now it is under
We have very clearly held in BSNL case, if it is a dead case, dead claim.
Now that
Dead claim would refer to a situation where the parties will not be able to approach a court of law for redressing their grievance.
Exactly what I want to say. Yes, in this case, the facts in the court is clear that it was purely a claim for money.
Not
I just mentioned.
the law is not declared on that basis.
Straight I will part one of the judgment. Three judges went. What it said, because a lot wanted to know whether I can maintain a suit. The moment I can maintain a suit, I am as well entitled to go for arbitration proceedings.
Yes.
Now, the category of judgments, including Chotanben's case, the series of judgments, including this one report to the state, is that limitation is always a mixed question of contract.
Correct.
Now, that is an issue which requires to be decided after some materials are placed before a concerned adjudicating authority to find out as to whether or not a particular clause is within the limitation or out of the
Therefore,
limitation.
you will have to point out, yes, these are the communications we have said. Parties have understood. That is why it has been taken up further, although it was mentioned 6 months ago. That is why those material you will have to place before the court.
Now, under section 11(5) or 11(6) of the Arbitration Conciliation Act, there are facts which requires elucidation for the purpose of determining whether there is an arbitrable clause or not. Then it immediately goes out of the purview of 11(5) and 11(6). It vests in the arbitrator under section 16. Because the recent judgment of the Supreme Court says that there is no question of delving into any factual aspects. If without there being any dispute on the facts, if it is apparent that that is what the BSNL's case said, if it is very much apparent from their own pleadings that my claim for the invoice is in the year 2011, I raised a dispute in the year 2018. So the Supreme Court said if you have raised the invoice in 2011, without saying anything, if you say that you have made a claim in 2018, once you raise the invoice suit for recovery of money, it is 3 years, you are part of limitation. This was a clear factual scenario. In cases where there are preconditions for performance.
Dealt with both the type of limitations. Anyway, I will not be able to hear this matter today. The election matters are there. We will fix a date. You come.
Fix a date.
At the request of learned senior counsel Shri D.R. Ravishankar, appearing for the petitioner, release this matter on 19th of July, next Wednesday. Really?
On
20th.
Number 7, Akshay Kumar J. Second time.
I can understand if petition under section 9 is pending or a suit is pending. 482 with Samandal. A week's time is granted at the request of learned counsel for petitioner to take fresh steps for service of notice of the respondent. Next matter, no, same, but you will have to furnish correct address.
That will mean like the registered address of the company.
If the shara on the postal cover is that no such address, then you will have to furnish correct address. What is the use of taking steps to the same address once again?
I checked now in actual website, it's the tracking number. I checked. It says that the respondent is vacated only
Correct.
same address.
So if he has vacated, and you know that,
I didn't know that.
now you have come to know after the postal shara has come, then
I did.
you have to you will have to furnish the correct address first and then take steps.
Same address they have appeared in the 282.
That is over, sir. Since the postal shara, what is it? On the notice sent to the respondent. What is? Commercially, addressee left, the petitioner is required to furnish the correct address and take steps for service of notice in the respondent. Full stop. 2 weeks time is granted to do the needful. Same order, ಎರಡನೇ matter ಅಲ್ಲಿ list this matter along with CMP number 151 of 2020. Huh? No, not on the 482. The petitioner is also permitted to take out hand summons. Huh? Rainbow Drive layout. ಅದೇ ಅವರು the request of the learned AGA released this matter on 19th of July to enable the concerned Tahsildar to submit a report as was directed in WP number 19563-573 of 2022.
Open money drain low lying solution. ಈ ಸಬ್ಜೆಕ್ಟ್ ಅಟ್ಲೀಸ್ಟ್ ಅದನ್ನ ಪ್ಲಗ್ ಮಾಡಿದ್ರೆ ಪ್ಲಗ್ ಮಾಡೋ ಪ್ರೋಸೆಸ್ ಟ್ರೈನ್ ಮಾಡೋ ಅವೇರ್ ಬರುತ್ತೆ ಫ್ಲಡಿಂಗ್ ಆಗಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಈ 123 that is not even they do it not.
There is no question of plugging, sir. Water is flowing from one side, it has to pass and go through to the other side. Ah, 20th. All right. Was there an interim order passed?
Yes.
Huh? Only till next date? Interim order granted earlier stands extended till the next date of it. Yes. Matters called out. There is no representation for the petitioner. Stop. Interim orders were passed by this court on 12/4/2023, restraining the respondents from proceeding with the auction, subject to the petitioner. The date 9/3/2023. Subject to the petitioner depositing rupees 2 lakhs on or before 30th of March 2023 and to deposit a further sum of rupees 2 lakhs within 12 weeks thereafter. Stop. It was also directed that if the directions issued by this court are not complied, the interim order shall stand automatically vacated. Stop. On 12/4/2023, when the matter came up for preliminary hearing, learned counsel for petitioner had submitted that a sum of rupees 2 lakhs was deposited on 9/3/2023, in compliance of the directions issued by this court. However, the other sum of rupees 4 lakhs were not deposited. Stop. Submitted that the said amount also will be deposited. Stop. Interim order was accordingly extended. Next para. On 7/6/2023, there was no representation for the petitioner. On 14/6/2023, the submission of the learned counsel for petitioner were placed on record. So, it was also directed that if the petitioner is not able to comply with the directions issued by this court, this court will have no other option than to dismiss the writ petition. Stop. No information is forthcoming at the hands of the petitioner regarding the compliance of the directions issued by this court. Stop. Consequently, the writ petition stands dismissed.
Serial number 10.
Well,
10 ಇವಾಗ ಇಷ್ಟೊತ್ತವರೆಗೂ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ ಅದೇನೆ 10.
Sorry.
Yes. Report who had to submit. Provisional order has been issued. And notice also is issued. The petitioner is a complainant or owner of the property? Ah. Ah. Hmm. Hmm.
There are 96 participated by the construction of the said building.
So,
The act has been passed. There are
ಅದಕ್ಕೆ ಮುಂಚೆ ಕರ್ನಾಟಕ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ಸ್ ಆಕ್ಟ್ ಮತ್ತೆ
the issue the notice in the year of 2021 of it.
ಸೊ
Under the BBMP Act of 2021.
Yes.
We got this report of country by my objection.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡ್ತೀರಾ? Actually information is available. We'll have to remove the deviated portion.
Again, next week also. And next week also. Take an instruction from the client and take a permission for the father.
Please file it along with a memo. Huh? Learned counsel for the respondent BBMP submits that the report is ready. So the same is required to be filed along with the memo. So learned counsel shall also furnish a copy of the report to the learned counsel for the petitioner. Stop. Release this matter on 19th of July. At 20th. The order granted earlier stand extended till the next date of hearing. ಏನ್ ಪಾಸ್ ಅವರು ಎಲ್ ಕೆ ರಮೇಶ್ ಹಾ ಏನು ರಿಪೋರ್ಟ್ ಫಿಲ್ ಮಾಡ್ಬೇಕಾಯ್ತಾ? ರಿಪೋರ್ಟ್ ರೆಡಿ ಇದೆಯಾ? ಹಾ
We will take this respondent to the party.
Hmm.
And it's allegation also strong side.
Ah.
Now they have filed an affidavit. Now they said that part is different from civil committee. Part of the background complaint, these are the court in an institution in PL where Arbitration is appointed as surveyor and identified this part again.
ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
You copy ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ
Now is the statement is not in part. My specific case is in the plan which was submitted in this layout, civil committee site is different from part. Now this construction is on civil committee site.
But he was allotted that property. He has been allotted that property. Huh? Whatever property was allotted to him.
There is no such allotment. It's not allowed. But the civil committee site, what are the years mark in the plan? Now he wants to put up construction and he wants to.
Please give the affidavit.
My directive to get a clarification and to place all those details, there is action plan, also approved layout, approved license given by the government.
No, why have you not stated anything as to how which property you are the owner of which property and where you are putting up construction?
That is not the allegation. I
Huh?
have not taken construction as on my old construction.
No, but he has very clearly said both block 1 and block 2. I am not concerned. I am not the owner. I am not putting up any construction in block 1, block 2 ಅಂತ ಹೇಳಿದ್ದಾರೆ. Yes. Yes, Mr. Ramesh.
The construction which they are now putting up on the symptom side, let it produce the sanction plan and license with the authority. Issued. I have no issue at all.
The next year, this was the subject matter of PIM. In PIM matters, after hearing matter matters. The court was.
Yes, Mr. Ramesh. Huh? I mean, I had pointed out to you last time. The society, if the society is coming before this court, that's a different matter. You can't contest this matter as a private individual or even as the president of the society. Madak barodilla. Madidira. Along with that one, you have filed a resolution of the society.
Yes.
Yes. No, that's all right. But what is the complaint? What is your complaint?
My complaint is, my lord, initially the layout.
The society has formed the layout.
Yes. And they have allotted, and even at the time PDA has approved this CS site and parks.
Yes.
Is as it is was there.
Yes.
My lord, they were, the society was called upon to pay amount with the development charges. On that development charges, they approved some report to obtain stay. And only on the development charges. So as this matter is concerned, there is no arbitration at all till date. Now, the allotment in terms of site was they are constructed and developed. Now, the CS site and parks, these persons, particularly this respondent five, even successfully attempted to encroach and construction.
Who is he?
He is a private person in the local landlords.
He has not purchased any
Any
site here.
No allotment also. No allotment also, no, and also not purchased any site in there. There are, there are local real estate agents are developing market. They one by one with the pollution of local aids and local corporations, they are acting with CSI and parks. When acted this part by we are committing the sample code. This are after anything the matter get appointed a corporate survey department the higher authority to conduct a survey and to give the report. Report is also given by that and also placed at page number 54, where the parks are identified and it has been now. Block 1 was the block
This respondent number 5 is also a party to that proceeding. Again, respondent number 5 is there. PR Srinivasulu. PR Srinivasulu, no? ಅಲ್ಲಿ BR ಶ್ರೀನಿವಾಸಲು ಅಂತಿದೆ ಪೇಜ್ ನಂಬರ್ 21 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 is ER ಶ್ರೀನಿವಾಸಲು.
I kindly take the matter to page number 56, page number 56. He arraigned as number 6 in the conclusion where the Salmon court after reading the matter disposed the matter. He is 6.
That was also a PIL.
No, that continuation of the same PIL.
Continuation of the same PIL.
Yes, earlier they have taken the review of the file. Now, because this all will put appointing as a corporate officer, conducted survey, and block 2 was clear. And now fencing was met, and it was improved. Block 1, there was civil litigation, they said that civil litigation is there, and this matter is pending before this all will put in RFA. RFA, they are done. Now, even RFA are a small plate of 20 by 25 in the corner. That's not the issue for the entire park in block 2. Now, my
They noticed that that RFA was pending, and now you have placed a copy of that RFA. Anjappa, Papaya, Raghupati, Narayana. And this fifth respondent is in no way concerned with that RFA.
He is not part of the RFA.
Yes, sir.
And now parts are identified. CSIs now they give their own number.
Yes. Huh? Why have you not given any information here? Purpose. Sir, but you also have to say you are the owner of so and so property, and I am putting up construction on the property purchased by me. Then why they have made you a party here? What is the allegation that they are trying to make against you? Therefore, you have to state that. If you don't do that, then the court will have to infer something else. Please take it back. Although an affidavit is sought to be filed by respondent number 5. On going through the affidavit, this court finds that complete information regarding the right of the fifth respondent in putting up any construction is not stated. Stop. On the other hand, it is simply stated that the fifth respondent is not putting up any construction on block 1 or block 2 of the park area in the layout. Stop. Since it is park bar TSI. It has been alleged by the petitioner that the fifth respondent has been putting up construction unauthorizedly. Stop. Therefore, the fifth respondent has to give complete information as to what is his right to put up any construction in the layout. Stop. Next para. Release this matter on 19th of July. Other complete information on the other end. Why should we give full details? Yes. What to do further?
Report is concerned, record the details of report on 17/21.
You have filed.
That was filed on 17/23. And so for the improvement, there will be improvement in so far as current change of file, deputy to law. Having from each property. Filed on 17/22. If disclosure around 6.5, the property environment presentation council. The column is away from the from not for column.
No, you have initiated action. Allah. What was the grievance of the petitioner?
There is a princess that big will not to complete the project, we will check princess. So that will calculate. But the knowledge away from the property is belongs to the parents from the parents. If the parents we also quite a number of questions, W 917 or 23 before the 21st April 2023. Because it is not unlocked. Yeah, yes. That is not taken action even before the passenger because there is no requirement passage.
In terms of the directions issued on 5/7/2023, Learned Counsel for the respondent BBMP has filed a memo along with a show cause notice issued. A show cause notice dated 10/7/2023 issued by the Deputy Commissioner, bracketedly Administration, close BBMP, to Sri E.N. Raghavendra, the third respondent, Assistant Executive Engineer. Then a council for the respondent BBMP further submits that a report, survey report, along with sketch, has also been filed on 7/7/2023. ಅವರು ಕಾಪಿ ಸರ್ ಮಾಡಿದ್ದೀರಾ? ಮೈಸೂರಾ? Along with the memo, the learned counsel has also furnished a copy of the email sent by the learned counsel to the learned counsel for petitioner. Stop. Correct. There is no representation for the petitioner. Stop. Raised this matter on 19th of July. Yes. ಅಲ್ಲ ಅದು ನೀವು ಯಾವ ತರ ಇತಿಹಾಸ ಮಾಡ್ಕೊತೀರೋ ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದು. We are not going to say anything. What do you want? Otherwise, we'll have to. At the joint request of the learned counsel, release this matter on 19th of July. This matter of the service of notice on respondent number 5.
Number 17.
Matter of the service of notice on respondent number 6. Office objection is overruled. Yes.
At the time of asking the property, return picture money property
It is the provision which says the reserve price has to be shown.
Rule 17 regarding about doubting the property. It does not say. The other Supreme Court said often is going and being conducted. As ready. See, pertaining to the word recovery of public use. There are people as the option is being made for the recovery of public use. But undoubtedly, public money should be recovered and
Paragraph.
paragraph 13, but paragraph 17. It becomes a legal obligation on part of authority that property be sold in such a manner that it may fetch the best price. The essential ingredient for such sale remain the correct valuation report and fixing the reserve price. In case proper valuation has not been made and the reserve price is fixed, taking into consideration inaccurate valuation report, the intending buyer may not come forward treating the property as not purchased by them. As a many person or big person may not like to be involved in the small sale or deal. Second matter regarding valuation and reserve price. What value means worth or cost or price of or sale of thing or property. And 19. If you are this court explains that the meaning of reserve price explains that you keep the price which the public auction start and the auction details are not permitted to give it below the sale price. That is no detail auction. What not in the auction is being that what is the most due to me is that first point is saying not each
Learned AGA. Take notice for response number 1 and 2. Who had appeared for this? The third respondent? Where is that? Learned Counsel Sri with Vishwanath R. Hegde, who had appeared for the third respondent in the earlier round of litigation in WP number 2937 of 2023, is requested to take notice for respondent number 3. Learned Counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for respondent number 3 and a copy on the Learned AGA. Full stop. Next para. Learned Counsel for the petitioner submits that since the petitioner was unable to comply with the directions issued by this court while granting interim orders in favor of the petitioner, the petitioner will not say anything regarding the will not seek to stay the further proceedings. So, however, the Learned Counsel for petitioner submits that in the auction notice dated 19/5/2023 at annexure G, no information is provided regarding the reserve price. So, Learned Counsel submits that the Honorable Supreme Court has time and again held in many cases, including Ram Kishan and others versus State of Uttar Pradesh and others, 2012 bracket 11 SCC 511, that unless the reserved price is fixed after ascertaining the correct valuation, comma, no purchaser would come forward to purchase such property. So, it would be a legal obligation on the part of the authority to show the reserve price in the auction notice. It's correct. Next paragraph. In that way of the matter, comma, since the auction is to be conducted today, comma, the second respondent, recovery officer, and assistant registrar of cooperative societies is directed not to confirm the sale, comma, even if any party comes forward bidding for the property interest. Yes. Release this matter on 19th of July.
Number 2. Number 1. Is our opinion. Is our opinion.
Huh? Fresh matter. Learned HCDP takes notice for response number 1 and 2. Learned counsel Srimati Vaishali Hegde is requested to take notice for response number 3. Notice to response number 4 is dispensed with for the time being. Stop. Learned counsel for the petitioner is directed 2 sets of the writ petition along with annexures on learned counsel for response number 3 and a copy on the learned HCDP. Full stop. Release this matter tomorrow. Huh? All this have to be taken up with the urgency. Yes. Same order. Same order. ಏನ್ರಿ ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಬೇಕ್ರಿ ದಿ ಅಥಾರಿಟಿ ಟು ಕಂಡಕ್ಟ್ ದಿ ಎಲೆಕ್ಷನ್ ಇಸ್ ದಿ ಸ್ಟೇಟ್ ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ಸರ್ ಇರ್ಬೋದು he has only taken instructions from the state election commission sir if you don't want to it is difficult learned HCDP takes notice for response number 1 and 2. Learned counsel for petitioner is directed to serve a copy of the petition on the learned HCDP. Stop. Since it was noticed that the state election commission is not made a party respondent to this proceedings, comma, learned counsel for the petitioner makes an oral request to permit the petitioner to implead the state election commission as a party respondent to these proceedings. Stop. Leave granted. Full stop. Learned counsel shall carry out the amendment in the cost forthwith. Learned Counsel Srimati Vaishali Hegde is requested to take notice for the third respondent, State Election Commission. Learned Counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the Learned Counsel for respondent number 3. Release this matter tomorrow. HCGP for 1 and 2, Vaishali Hegde for 3. Notice to respond number 4 is dispensed. Same order. How is it?
Recording model. Therefore, from the election petition.
Petitioner is A.N. Ajay Kumar. The contesting respondent is
Number 2.
Nataraju. Nataraju. Nataraju has got 295. Petitioner has got 300. I think it was declared, they knew the.
Reservation may be other. Earlier it was quoted as invalid. 4 was invalid. Now they are counted invalid on their present petition. And also, earlier taken 54 was now reduced to 50. So it's come, I don't know. Because 4 total casting vote is 631. 1 voters, each voters have over to cast 2 votes. Out of 4 votes, correct, invalid. In first counting, in present counting, there is no invalid vote. At the same time, all the parties, contesting parties have the right to objection and all the given representation.
Tahsildar. So let them produce earlier, what the earlier record you maintained. You know, earlier, what- that has to be.
He has not, has he said anything about the invalid votes? Why? Why was it declared invalid? Why? ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ವಲ್ಲ ಅವರು?
The vote shows it, total 262 vote clear. ಆರು 31 vote ಅಷ್ಟಿಗೆ 200 vote ಮಾಡಿಲ್ಲ, ನಾವು 262 vote exceed ಆಗಿಲ್ಲ. Now as per the recent recounting method, 1,278 votes.
Perfect. In terms of the directions issued on 26/6/2023, the Tahsildar, Udpi Taluk, with the help of the assistance of the Election Commission, has proceeded to do the recounting on 6/7/2023. Stop. A sealed cover containing the report of the Tahsildar along with all other information are made available. Stop. On opening the sealed cover, this court finds that as per the recounting, the petitioner has obtained 300 votes, while the second respondent, who is the contesting respondent in the matter, has secured 295 votes. Stop. Next para. Learned counsel for the second respondent submits that while the counting was earlier held, the returning officer had held that 5 votes were invalid. 4 votes were invalid. Stop. In the recounting, nothing has been said regarding the invalid votes. Stop. It appears that all the 4 votes which were declared invalid earlier have now been considered as valid votes and have been taken in favor of the petitioner. Full stop. Next para. The Tahsildar, Udpi Taluk is required to file an affidavit in this regard, clarifying as to how the 4 votes which were earlier held invalid is now treated as valid votes. Stop. If necessary, along with the affidavit, the 4 invalid votes in their original shall also be furnished before this court. Innೊಂದು paragraph. It was also pointed out by learned counsel for respondent number 2 that insofar as one of the contestants, that is SS Jagdishappa, respondent number 4 is concerned, earlier it was shown that he has secured the body 54 votes. In the recounting, it is shown that the fourth respondent has obtained 50 votes. 50 votes, full stop. Therefore, it is sought to be contended that as per the total number of votes polled, there is a difference of 4 votes from what was declared earlier. Full stop. Last paragraph only, the Tahsildar is also required to answer the objection raised by the learned counsel for respondent number 2 as to how 4 additional votes ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ? Invalid votes, now it has become valid and it has gone to the petitioner. So there is no additional.
Invalid
The Tahsildar is required to address the objections raised by the learned counsel for respondent number 2 as to how the 4 votes which were earlier shown in favor of respondent number 4 is now deleted, and for what reason? Yes. ಅದಕ್ಕೆ ಹೇಳಿದ ಒರಿಜಿನಲ್ since the results are opened and declared, the cover along with the documents are returned to the learned AGA. Release this matter on 19th of July.
I appear for respondent number 14, my lord.
ಇವ್ರು ನೋಡ್ಬೇಕಲ್ಲಪ್ಪ, ಅವ್ರ ಇನ್ಫಾರ್ಮೇಶನ್ ತರ್ಬೇಕಲ್ಲ. ನೀವು ಇವತ್ತು ಕೊಟ್ಬಿಟ್ಟು ಇವತ್ತೇ ಮಾಡ್ಬಿಡಿ ಅಂತ ಏನ್ ಮಾಡ್ತಾರ ಅವ್ರು? ಅವ್ರಿಗಲ್ಲ. The learned AAG has to secure instructions and make submission. ಬಂದಿಯಮ್ಮ ಇನ್ಫಾರ್ಮೇಶನ್? ಸೀರಿಯಲ್ ನಂಬರ್ 3. More. Yes.
Number 5, my lord, I appear for respondent number 14. Last time your lordship passed an order that I raised objection to the report saying that it's equal number of votes, and one number, it was announced in the meeting that my client got one more X. So he was asked to bring the and explain. Last time your lordship passed an order. On 5/7.
ಈಗ ಅದನ್ನ ಯಾರು ವೆರಿಫೈ ಮಾಡೋದು? ಹೆಂಗ್ ಯಾರು ಚೆಕ್ ಮಾಡೋದು? ನೀವೇ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಇನ್ ದಿ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದಿ ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ಸ್, ಯು ಪ್ಲೀಸ್ ಡೂ ಇಟ್. Sir, the actual information will be verified by both of you in the presence of the learned AGA. Other than that, nothing can be done. You can't expect the court to go through all this information. Please go sit with the learned AGA. He has got the original ballot papers, you sit with him and get it verified. Ade ellanu ನೀವು you please get it verified in the presence of the learned AG. ಎಲ್ಲ ತರಬೇಕು. ಎಲ್ಲ ಇರುತ್ತೆ. ಎಲ್ಲ ಇರುತ್ತೆ. Learned AGA submits that the original ballot papers have been furnished by the returning officer. Stop. The learned counsel for petitioner, learned counsel and the learned counsel for the contesting respondent
Number 14.
are requested to verify the ballot papers and the votes polled in favor of the contestants, including the invalid votes, in the presence of the learned AGA. Full stop. That exercise shall be undertaken this evening.
Tomorrow, my lord, I have to get my party from. I am for respondent number 14 contesting. Tomorrow, my lord, any day tomorrow.
Party alla, I am asking only the advocates to do it, not your parties.
No, because he has filed an affidavit, I want to verify from him also. That's why one time ನಾಳೆವರೆಗೆ.
No.
ಇವತ್ತಿಗೆ ಕಷ್ಟ ಆಗುವುದು ಅಂತ.
Contentions you wanted to say, you have already stated.
Yes, my lord.
I am permitting the learned counsels to verify the facts, sitting with the learned AGA. I am not permitting the parties to go before the learned AGA.
No, I wanted to
It
ascertain.
is only the advocates who are to go and sit with the learned AGA and verify the facts. Adu bere. That is before the returning officer. You are before the court now. So therefore, since objections are raised, I am permitting you to verify the facts in the presence of the learned AGA. The original information will be made available. You please verify. And if there is any discrepancy, you please point out.
It was CD was there. That's what I was informed. I don't know whether they have brought it. It was recorded. The meeting.
I can't understand what you are submitting. The information, original information will be made available to you. You will see in whose favor it is polled. You will have the total number of ballot papers which are declared and the number of ballot the papers that were declared invalid. All that information you will have. ಏನಾಗುತ್ತೆ? It is the responsibility of the learned AGA. Tampering ಆಗುತ್ತೆ. Sir, ಅದು ಹೆಂಗಾಗುತ್ತೆ sir? The responsibility is with the learned AGA now. Let him do it. Please go before the learned AGA this evening. Get it verified. Huh? Early, ಎಷ್ಟೊತ್ತಿಗೆ? 5:30. The learned counsels are requested to
One submission.
undertake the exercise in the presence of the learned AGA at 5:30 this evening in his chambers.
One submission I want to make, my lord.
Release this matter tomorrow.
One submission I want to make, my lord. There was
Yes.
a recording of the proceedings. Whether they have brought it, I do not know. In the recording in CD, that was, if it is brought, it could be known how it was declared as one vote for me extra or additional, and I was that was announced in that meeting.
That is not important. Yes. If there is anything, you please make submissions tomorrow. We will see. Yes. ಈಗ ನೀವೇ ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡ್ದಂಗೆ the more time is given, it will be more difficult. So I want this to be conducted today itself. Yes. Yes. Huh? Objection. ಏನ್ ಮಾಡ್ಲಿ? Huh? It's coming up for the first time. You filed caveat. Please serve a copy. Learned AGA. CGP takes notice for respond number 2. Learned counsel Sri Santosh HR has entered appearance for respond number 1. Learned counsel for petitioner is directed to serve a copy of the petition on the learned counsel for respond number 1 as well as the learned HCGP. Release this matter on 19th of July. ಸರಿ, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಇವಾಗಲೇ ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡ್ಲ? ಏನ್ ಸ್ಟೇ? You were declared the ಅದೇ then if you both of you are agreeable on the factual finding that both of you have secured equal number of votes. If you have agreed, then we will ask the returning officer, the second respondent returning officer, to declare the results by picking up the lottery in terms of the rules. Huh? Button. Learned counsel for the petitioner submits that although the election tribunal declared that the petitioner as well as the first respondent have secured equal number of votes. That is 375, 186 each. The tribunal has proceeded to hold that the election itself is void. It's all. ಯಾವ provision? Section na. Then a counsel for the petitioner would therefore submit that even if the decision of the tribunal is that two candidates have secured the highest number of votes and equal number of votes, then in terms of in terms of section 21 of the Karnataka Gram Swaraj and Panchayat Raj Act of 1993, ಅವರೇ ಮಾಡೋದು. This order has been passed by the yes. All right.
Non-counsel for the person will therefore submit that even if the decision of the tribunal is that no candidates have secured the highest number of votes and equal number of votes, then in terms of section 21 of the Act 1923,
A designated court shall decide between the said two parties by lot and proceed as if the one on whom the lot falls has received an additional vote and shall be declared as the returned candidate. Stop. Next para. Learned counsel for the contesting respondent number 1 does not dispute the submission made by the learned counsel for petitioner. Full stop. Next para. In that way of the matter, the impugned order, impugned judgment dated 22/5/2023 passed by the senior civil judge and JMHC at Ennarpura in election petition number 2 of 2021 stands modified while setting aside a portion of the order wherein the declaration of result in favor of the petitioner herein was held to be void. Stop. The matter stands remanded back to the election tribunal. The direction to follow the procedures contemplated under section 21 of the Karnataka Gram Swaraj and Panchayat Raj Act, 1993, and declare the result according. Stop. Next para. The parties are directed to appear before the election tribunal on July 24th, 2023, without waiting for further notice. Yes. Yes. Hmm.
48.
Yes.
Huh? Page 48. 34 gram panchayats they are considered. And the contention is there are 2 gram panchayats are not in existence. Because it was being reconstituted by the state government. How it's been reconstituted? So Lord, we have to take it, moment it is reconstituted within the taluk, and have to allot the reservation. That is how we take it into the.
Reconstituted and it is merged with some other.
Not saying initially there were 36 gram panchayats there were. Who have merged? They have gone out.
Allah, 4 were supposed to be merged.
ಇಲ್ಲ ಆಗಿಲ್ಲ. ಎರಡೇ ಆಗಿರೋದು.
ಆಗಿಲ್ಲ ಅಲ್ಲ, you have issued the notification.
We had not said some are being reconstituted. There was a proposal, but the state government has only upgraded 2 gram panchayats. The fact of the matter is they have upgraded only 2. 2 others, they are still in it.
So actually, your government order dated 4/12/2020, wherein you had shown 4 gram panchayats
Yes.
to be taken away and to be merged.
That was the proposal by the government. Based on that, we have not conducted the election.
So now you are going ahead with the elections to both these.
Once they give us the entire list of thoughts, we'll have to know they have actually fixed the seats also. We'll have to hold the general election to those 2 gram panchayats. These reservations automatically will apply to those. Otherwise, for them,
ಅಲ್ಲ ಅದ್ರಲ್ಲೇನು ಡೌಟೇ ಇಲ್ಲ. If you are now saying that although what was shown in the 2020 notification was that 4 gram panchayats will be excluded,
yes,
but factually only 2 were excluded,
have been excluded.
and the remaining 2 have continued, and therefore.
Panchayat. But anyway, they never came. Balu, this is Belur.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ, see their grievance is, of course,
BCA.
there are only 3 posts BCA. ನೀವು ಇವ್ರಿಗೆ ಈ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ತೋರಿಸಿದ್ರಲ್ಲ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ, according to them and according to your notification which was not in existence. So if elections are not going to be conducted to those gram panchayats and you have simply shown reservation, ನಮಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ, that was the grievance.
34 ಇವಾಗ reconstitute ಮಾಡಿದ್ದಾರೆ ಗವರ್ನಮೆಂಟ್. BCA ಅವರು ಬರೋದು ಲ್ಯಾಂಡ್ ಅವರಿಗೆ
ಅಲ್ಲ, ಅದು ಬೇರೆ ವಿಚಾರ. That is a different aspect. Continue. Yes.
Actually, right, because there are no existing members first thing. Even in the final list of events what they have issued, they are very clearly mentioned only 30.
There are no existing members.
There are no existing.
There is no gram panchayat.
There are no existing members. No existing. There are yes.
Panchayat was being reconstituted. It has been reconstituted. Now for Shetty Hally, there are 15 seats. That's a member seat. 15. Then for Chowdhury, 11 seats have been fixed. The horizontal SC.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಎಲೆಕ್ಷನ್ ಆಗಿಲ್ವಲ್ಲ.
General election you when I do. That's why in my guidelines also I say, even where the term is not expired, because I'm fixing for the taluk. Suppose some term is not expired.
General election has to be conducted there also.
Yes, because I have to give reservation for a taluk. Otherwise, our very general protocol. So
Then you will have to declare the general election.
the proposal your government is there. Issue ಮಾಡಿದ್ದಾರೆ. You have to take, we have been behind that.
That's based on this matter, something they included.
If they had not done it, it would have been a problem. Please understand. So what they have done is correct.
But for at least president, vice president, and BCM is just 3. Have only 3 slots for that, and they have included it in one of these categories.
Correct that, but they have followed the guidelines. You cannot have a grievance. You could have a grievance only if they had not followed the prescribed norms as per the guidelines. That is not your contention.
In their guidelines, in fact, there is a portion where it says that the deputy commissioner has to check how many members are there in one, elected members are there, etc.
That's all right. That's all right. Now, out of the 15, in terms of the population, they have also fixed where they stand.
Below reserve gets SC. They can't escape that because descending order, if they have got SC, means it will not flow down to PCA at all.
The contention is, we may have a fighting chance in this in case it is not included in rotation. Even in their final list.
Now it has to be included, madam. Now the clarification has been given. They will conduct the general election for that also. And as soon as they conduct the general election, they'll have to follow this same reservation.
That-
The state government will do the needful.
Then- Yes.
Correct, madam, but please understand, there are subsequent developments. You are referring to notification which was issued in the year 2020, and you do not know what are the subsequent developments. We saw the clarification, and it is now being submitted. Though 4 were supposed to have been taken away, only two were removed. These 2 will continue. How can you have any grievance about that, madam? You don't belong to this constituency. Then, Berkeley. Then that constituency has to have a elected representatives. They have to have a local body. They are going to do it, man. Let them do it. We can't prevent them from doing it. The grievance of the petitioner was noticed yesterday when the matter came up for preliminary hearings. Stop. It was contended that as per the government order dated 4/12/2020 at Annexure B issued by the State Election Commission, 4 constituencies of Kolar Taluk were to be left out of the elections of the Gram Panchayats to the Taluk. Adna constitution. Stop. However, in the notification, impugned notification dated 28/6/2023, reservation is also provided for 2 of such Gram Panchayats which were supposed to have been removed from the fray of elections, namely Chettihalli and Chowdadevanahulli. Stop. The learned counsel appearing for the State Election Commission was therefore required to get clarification. Stop. Next paragraph. Today, learned senior counsel Sri K.N. Panindra appearing for the State Election Commission submits that it is true that in the government order dated 4/12/2020, it was stated that 4 Gram Panchayats out of in the Kolar Taluk shall not continue as Gram Panchayats, since they would be merged into a local body under the provisions of the Karnataka Municipalities Act. Full stop. However, subsequently, Chettihalli and Chowdadevanahulli were not merged in the municipalities. Although a part of the Gram Panchayat may have merged. Full stop. However, Chettihalli and Chowdadevanahulli will continue as Gram Panchayats, and therefore the reservation have been provided. Full stop. Next para. At this juncture, learned counsel for petitioner submits that the elections to the Gram Panchayats were held in the year 2020-21 and no elections were held to Shettihalli and Chowdadevanhalli. So therefore, the question of reserving the posts for the president and vice president would not arise. Full stop. To this, the learned senior counsel would submit that the state election commission has already returned to the government for giving all informations to enable conducting of the general elections to the 2 Gram Panchayats. Full stop. As soon as the requisite information is provided by the state government, the general elections to the 2 Gram Panchayats, namely Shettihalli and Chowdadevanhalli, will be held very soon. Full stop. Thereafter, the elections to the post of president and vice president in terms of the reservation provided in the impugned notification dated 28/6/2023 will also be conducted. Full stop. Next para. In view of the apprehension of the petitioner being clarified at the hands of the respondent state election commission, this court does not find any other reason to interfere with the impugned notification. Full stop. Consequently, the writ petition stands dismissed. Election na? Huh? Password. Yeah.
Same set of facts, but in this case of annexure, A IDC, 1993, NC radio.
Annexure?
Annexure A increase in the 16. We can repeat the same kind.
Nimdi nim information is checklist. Yes. Yes, really. Really.
Two times rotation in 1923 was not agreed. And scheduled time the population is also compared to the AC. That's the one. Even though in 1983, till again the result of AC. ST was complete.
How the yearly sir? ಯಾವ constituency yearly sir? Huh? Adun bidi, I have got more information. So I am asking you name of the constituency. Yado?
Serial number. Serial number.
Rapte.
Serial number.
Rapte. ಏನಾಗಿದೆ 1993 it was given. ಆಯ್ತು 2010. Yes. SC female.
SC female also given the representation. All the other, you do share this notification and the same thing about reported.
You are asking for ST.
SC lady.
ST,
We can say every time they are resident for 30 years, they are winning the majority. Even the population is not high in the locality.
Ah.
Kind of see the representation, even I tell you in advance. Dated 30 1 week before I have gone.
ಅದೆಲ್ಲ ಬಿಡಿ sir, you please point out from the list now.
Kind of see that.
Ah.
93 SC lady was again repeated to 2010.
Huh?
2010 again SC lady was repeated. Again 2023 was repeated. Price has been repeated. One time only, 30 years ago. Not even repeated one time, ST lady. ST one side ಮಾಡಿದ್ರು 2005 first year. ST 2010 ನಲ್ಲಿ first term ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ST ಕೊಟ್ಟಿದ್ದಾರೆ, ST female ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈ ಸರಿ SC ಫಿಮೇಲ್ ಕೊಟ್ಟಿದ್ದಾರಾ? ಹಾ.
Same repeated third time 2019 ಅಲ್ಲಿ 2010 ಅಲ್ಲಿ repeated. This are the report was allowed to be petition by same principle. Because in the 13
ಹಂಗಲ್ಲ 2005 ಅಲ್ಲಿ ST ಬಂದಿದೆ. ST ಬಂದಿದೆ. So it all depends on the total number of seats that are available for scheduled tribes. There are only 2 in your Gram Panchayat, only 2. Scheduled caste ge 4. So therefore the repetition will be more. You can't have any grievance like that. 4 scheduled caste, 2 scheduled tribe. So naturally ಹೌದು ಏನ್ ಮಾಡೋದು?
Constancy number 1 to serial number 1 to 10 again 11 to 17.
ನೀವು ಆ ಲಿಸ್ಟ್ ನೋಡ್ಬಿಟ್ಟು ಹೇಳೋದಲ್ಲ, ಹಂಗಲ್ಲ, ದಟ್ ಇಸ್ ನಾಟ್ ದಿ ವೇ. See, the requirement of law is that they should have information as to the highest number of seats and population of SCs first. SC ಇಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಬೇಕು, ಅಲ್ಲಿ ಫಸ್ಟ್ ರೊಟೇಷನ್ ಆಗ್ಬೇಕು. ಆಯ್ತಾ? ಇಲ್ಲಿ 4 of your seats out of 8, 10, 14, 15 seats ಅಲ್ಲಿ 4 SC, 2 ಮಾತ್ರ ST. So going by the guidelines, since it has to commence from scheduled caste, ಅವ್ರದ್ದು ಇದನ್ನ ಮಾಡುವಾಗ, since the last time it was given was 2010. Adalla say sir, please understand, this is not the way you can look at it. Going by the guidelines, they have to follow this system, that first they have to give reservation for the SC category. Rotation, alli rotation ಮಾಡಬೇಕು. ಅದನ್ನ ಮಾಡುವಾಗ if your Gram Panchayat has been given SC reservation, because the last time it was given was 2010, how can you find fault? You have only 2 ST posts there. ಅದಕ್ಕೆ ಹೇಳಿದ್ನಲ್ಲ, first it commences from SC, not ST. So SC ಇಂದ ಕಮೆನ್ಸ್ ಮಾಡಿರುವಾಗ, if your Gram Panchayat is identified as a constituency which should get SC reservation, ಕೊಟ್ಟಿದಾರ, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಅದರಲ್ಲಿ ವುಮನ್ ಕೊಟ್ಟಿದಾರ, ಜನರಲ್ ಕೊಟ್ಟಿದಾರ ಅನ್ನೋದು, ಅದನ್ನ ದಟ್ ಇಸ್ ಇಮ್ಮೆಟೀರಿಯಲ್ ಫಾರ್ ಯು. ಬರ್ಕೊಳ್ಳಿ. The grievance of the petitioner is that in Rapte Gram Panchayat of Pavagada Taluk, reservation to the post of ST woman was never given, commencing from 1993 till date. Stop. Other ST woman. Next para. On the other hand, reservation was provided for SC woman 3 times. But twice earlier, and in the impugn notification, once again, reservation is given for SC woman for the post of Adhyaksha. Stop. Next para. Learned Additional Advocate General submits that in terms of the guidelines governing the rotation in reservation, which is in the form of a government order dated 25/5/2023, the election officer cum deputy commissioner is required to consider rotation in reservation amongst the scheduled caste categories first. So, it is pointed out that in Rapte Gram Panchayat, out of 15 members, 4 belong to scheduled caste community and 2 belong to scheduled tribes. Only 1 amongst them is reserved for backward class A, and 8 general candidate members. Stop. While working out the rotation in reservation in terms of the guidelines, the first step that is required to be done is to identify the Gram Panchayats in the Taluk, which are required to be assigned reservation of scheduled caste categories. So, having regard to the population and the previous occasion when the post of Adhyaksha of Rapte Gram Panchayat and the other Gram Panchayats are concerned, it was found that this time Rapte Gram Panchayat is required to be given scheduled caste reservation. Stop. It is only after assigning the reservation of scheduled castes amongst the Gram Panchayats in the Taluk, the next step would be to consider providing reservation to scheduled tribe categories. Full stop. In the present case, as stated herein above, since the first step was to identify the Gram Panchayats where scheduled caste reservation is to be provided, and while undertaking that exercise, having regard to the population and the total number of posts reserved in Rapte, which shows that 4 members belong to scheduled caste community, and the process of rotation in reservation suggested that the reservation this time has to be provided for scheduled caste category, the election officer and deputy commissioner has proceeded to concur with the results given by a computerized system. Stop. Next para. Idurdu GPVP do and paragraph ide. Adu nakum. Next para. Having heard the learned counsel for petitioner, the learned AAG, and on perusing the petition papers, this court finds that the respondent, election officer, deputy commissioner, Tumkur district, has followed the guidelines contained in government order dated 25/5/2023. Full stop. Moreover, since the process of rotation in reservation is now computerized and much of the work is done through a computerized process, no fault can be found in the impugned notification. We'll stop. Next para. Consequently, the petition stands dismissed. Same. Serial number 12. Sorry. ಇಲ್ಲಮ್ಮ ಇದಿಲ್ಲ ವರ್ಕ್ಶೀಟ್ ಇಲ್ಲ. ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ? How can you maintain this repetition? A preliminary objection is raised by the learned additional advocate general that the petitioner has no locus to have filed this petition challenging the impugned notification, since the petitioner is not a member of the Gram Panchayat and he cannot question the reservation made for the posts of Adhyaksha and Upadhyaksha. Full stop. Next para. Learned counsel for the petitioner admits that the petitioner is not a member of the Siddhapura Gram Panchayat. However, it is submitted that the sister of the petitioner is a member of the Gram Panchayat and therefore the petitioner is seeking reservation of backward class B woman for Siddhapura Gram Panchayat. Full stop. Next para. Siddhapura. ಅಲ್ಲ BCMB ಇಲ್ವಲ್ಲ? ಅಲ್ಲ BCMB ಇಲ್ವೇ ಇಲ್ಲ ಸಿದ್ದಾಪುರಕ್ಕೆ. ಹೌದು, ರಿಸರ್ವೇಶನ್ ಇಲ್ಲ. ಅಲ್ಲೇ ಸೇರಿಸ್ಕೊಳ್ಳಿ. Moreover, ಅಲ್ಲ the next para. The learned additional advocate general will further submit that the petitioner is seeking reservation of backward class B woman to the post of president of Adhyaksha of the Gram Panchayat. Stop. However, Siddhapura Gram Panchayat has no reservation for BCMB category. Stop. Therefore, on both counts, the writ petition has to fail. Stop. Next para. Having regard to the admitted fact that the petitioner is not a member of the Gram Panchayat and it has to be held, and therefore it has to be held that the petitioner has no locus standi to question the impugned notification, which provides for reservation for the post of Adhyaksha and Upadhyaksha of the Gram Panchayats in Pavagada Taluk. Full stop. Moreover, it has also been pointed out by the learned Additional Advocate General that for Siddhapura Gram Panchayat, there is no reservation in the category of backward classes B. And therefore, the question of permitting reservation in the said category to the posts of Adhyaksha or Upadhyaksha would not arise. We'll stop. Next para. Consequently, the writ petition stands dismissed. Yes. Yes. Yes.
But I belong to category A. But
ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮಂಚನಾಯಕನಹಳ್ಳಿ
category A.
Hmm.
But in 93 was category A. Now it has given category A female also. In 2010, category A female. Now again in 2022, 22, this category A female.
Now it's category A female.
Female. Category A and not but not only that, my lord, the post of president and vice president both are female. So we should be seen in next year. So category A female and general female. Total four are the members. Seven out of 4 are women. But now category A has been allotted to good girl, serial number 10. And BBMP case. Proportion president. Previously it was SC female. Taluk has 4 seats, 2 women, 2 men. Category A.
Vibhutikare is given category A.
And good girl is given category A, not category A. Previously, the vice president was category A. It has been repeated as president now. Vice president category A has not been repeated in my constitution, in my Gram Panchayat. Category A female I think came up again. But my lord could see at my Gram Panchayat, category A female was vice president in last term. Now it has been repeated as president. Till number 4. Previously it was vice president, now it is president. Their own notification says, Lord, the one who has given an opportunity for vice president in the post of president should not be considered for next term for female. And meanwhile, their own notification says both the posts, like vice president and the president, should not be female. My experience is, I have not been given opportunity since 1990. Only one thing identity category A was
The
given.
post of vice president is reserved for
This time it is reserved for general female.
general female. Yes, madam.
Category A.
Well, by petition for, you may petition page number 49, but they are stating is you may petition as page number 49. There at Ramnagar.
DCA. There are only 4. Yes. 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 There are 20 gram panchayats.
If that is an argument, serial number 1, NDC.
Yes.
1980 category A.
Yes.
2020 is category A. 2000, the previous term is category A. There's no female at all in that. That is the argument that it should be repeated. It's not. Category A female has not been repeated.
Ingalla. The 4 posts have to be rotated amongst all the gram panchayat. That is the submission.
He repeat again. Here female put it, here male put it. Female put category.
There are many gram panchayats which have not got this BCA till now. That is the submission.
In serial number 10, these are female put category A, 2000 serial number 10. In the checklist, ಈ category A ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ checklist serial number 10 ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ 2000 category A ಬಂದಿದೆ 2005 category female ಬಂದಿದೆ ಈಗ category A ಬಂದಿದೆ ಸೊ ಕೊಟ್ಟಿಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ rotation ನ ಪ್ರಾಪರ್ ಆಗಿ ಮಾಡ್ತಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ಕೊಳ್ಳಿ serial number 19 ಕೈಲಿ serial number 19 ಯಾವ ಈಗ ಈ ಗ್ರಾಮ ಪಂಚಾಯತಿ category A ಕೊಟ್ಟಿದ್ದಾರೆ serial number 19 category A female ಕೊಟ್ಟಿದ್ದಾರೆ 93 ಅಲ್ಲಿ 2007 category A female ಕೊಟ್ಟಿದ್ದಾರೆ now category A ಕೊಟ್ಟಿದ್ದಾರೆ
ವಿಭೂತಿ ಕೆರೆ ವಿಭೂತಿ ಕೆರೆ
serial number 1 ಇದೆ serial number 1 ಗ್ರಾಮ ಪಂಚಾಯತ್ category A 93 category A after comes
ಅಲ್ಲ ಇವಾಗ ಈ ಸರಿ ಬೈರಮಂಗ್ಲಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ
ಈಗ ಜನರಲ್ ಫೀಮೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ
ಮತ್ತೆ
ಜನರಲ್ ಫೀಮೇಲ್
ವಾಟ್ ಇಸ್ ದ ಯೂಸ್ ಆಫ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ ಟು ದಟ್ ಗ್ರಾಮ ಪಂಚಾಯತ್
they are saying that repeat ಆಗಿರುತ್ತೆ and female ಬರುತ್ತೆ ಅಂತ female ಬಂದಿಲ್ಲ ಎಲ್ಲ ಕಂಟಿನ್ಯೂ
ಪರ್ಫೆಕ್ಟ್
ಈಗ not in the correction for computerized correction not in that subsequently it has changed serial number 4 individual ವರ್ಗ A notification present notification correction ಗ್ರಾಫ್ individual ವರ್ಗ A ಅಂತ ಇದೆ ಈಗ ಫಿಮೇಲ್ ಮಾಡಿದ್ದಾರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಅಪ್ಪ ನೋಡಿ
ಯಾವ್ದು ನಿಮ್ದು?
ನಮ್ದು ಮಂಚನಾಯಕ ಕ್ಯಾಟಗರಿ ಎ ಇದೆ ಬಟ್ ವಿಚಾರ ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಈಗ ನೋಟಿಫಿಕೇಶನ್ ಎ ಫಿಮೇಲ್ ಮಾಡ್ತಿದ್ದಾರೆ ಕರೆಕ್ಷನ್ ಕಂಪ್ಯೂಟರ್ ಕೊಟ್ಟರೆ ಇದು total current consider 4 these are 4 category A one. Out of 2 is female, 2 is male. Mine was the first.
ಈಗ ಇನ್ನೊಂದು ನಿಮ್ ಪ್ರಕಾರ ಇದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು ಯಾವ್ದೋ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ? ಹಾ ಸೀರಿಯಲ್ ನಂಬರ್ 10
ಈ ಕ್ಯಾಟಗರಿ ಎ ಬಂದಿತ್ತು ಕ್ಯಾಟಗರಿ ಫೀಮೇಲ್ ಮಾಡಿ ಇದೆ ಬಂದಿತ್ತು ಮೇಲ್ ಮಾಡಿ
ಹಾ ಊಟದಲ್ಲಿ ಇಲ್ಲ ಮಹಿಳೆ ಬಂದಿಲ್ಲ ಅಲ್ಲಿ. ಅಲ್ಲಲ್ಲ ಇವಾಗ ಇವ್ರೇನ ತೋರಿಸ್ತಾ ಇದಾರಲ್ಲ ಇದ್ರಲ್ಲೂ ಕೂಡ ಅವ್ರಿಗೇನು ಮಹಿಳೆ ಬಂದಿಲ್ಲ ಅಲ್ಲಿ. ಮತ್ತೆ ಎಲ್ಲಿಗೆ ಯಾರು ಕೊಟ್ರು? ಆಮೇಲೆ ದೇರ್ ಇಸ್ changes. ಅಲ್ಲ even otherwise you please point out. Yeah, anyway, see, there is one thing what was going on in my mind even from the past few days. Even if you say it's a computerized process, it has to be transparent. The entire process has to be recorded. So if I don't know, if you go through that one, if you find that the initial results that were put out by the computer is this, then Alala, if you are now saying that the process is recorded, let them you please go through that. If there is some truth in what he is saying, then we'll have to answer. Because that is why he is saying. That is why he is saying that this process during the original process. Allah, you please ask your HCGP to go through that one, and if he finds there is something like this, yes, perfect. Then a counsel for the petitioner submits that even if the submission of the learned additional advocate general is to be accepted, that the entire process of rotation in reservation is being done through a computerized system, then information is available with the petitioner to show that the computer had put up the results showing that for Manchanayakanahalli Gram Panchayat, reservation of the post of Adhyaksha was to be given to the BCA category. Stop. However, the same has been subsequently changed as BCA woman. Stop. Next para. Learned AAG submits that the entire process has been recorded and the permission is granted. The learned AAG would go through the recording and thereafter come back to this court. Stop. Next para. Release this matter tomorrow.
Location B.
Vithalapura. ಯಾವ ತಾಲೂಕು?
From past year 1983 until 1999
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರಿ?
BCA ಜನರಲ್ ಈಗ 1983 ನಲ್ಲಿ ಒಂದ್ಸಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ 2000 ನಲ್ಲಿ ಎರಡನೇ ಅವಧಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ 2010 ನಲ್ಲಿ
BCA BCA
fourth time BCA women
BCA 2000 second term. 2010 first term.
ಯಾವಾಗಲೂ BCA women ಯಾವತ್ತೂ
BCA woman.
ಈಗ ಆಲ್ರೆಡಿ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ 2010 ನಲ್ಲಿ ಮೊದಲನೇ ಅವಧಿ
ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರಿ. ಬಂಡಿ ಹೊಳೆ
ಅವ್ರಿಗೆ
ಅದು ಕೊಡಿ, ನಿಮ್ಮ ವರ್ಕ್ಶೀಟ್ ಕೊಡಿ.
ಹಿಂದೆ ಮೀಡಿಯಾ ಕೊಟ್ಟಿದ್ದು ಈ ಮೀಡಿಯಾ ಆಗಲ್ಲ ಅಂತ ಒಬ್ಬರಿಗೆ ಹಿಂದೆ ಮೀಡಿಯಾ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ ಪಂಚಾಯತಿಗೆ ಎರಡನೇ ಅವಧಿಗೆ 2010 ಎರಡನೇ ಅವಧಿ ಆಮೇಲೆ ಲಾಸ್ಟ್ ಟರ್ಮು ಸಾಮಾನ್ಯ ಮಹಿಳೆ ಇದನ್ನು ಕೂಡ ಪೇಜ್ ನಂಬರ್ 25 ಈ ಕಡೆ ಹಿಂದುಳಿದ ವರ್ಗ ಆ ಮಹಿಳೆ.
ಮತ್ತೆ ಈಗ BCA ವುಮನ್ ಕೊಟ್ಟಿದಾರಾ ಇದಕ್ಕೆ? ಯಾವುದು ಹಿರಿಕಡಲೆ
ಯಾವ್ದಾವತ್ತು ಈಗ BCA ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದು ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲಾನು ಕೊಟ್ಟಿದ್ದಾರೆ. BCA ಅಂತ 2005 ಅಲ್ಲಿ ಎರಡನೇ ಅವಧಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವುದು?
ಒಳ್ಳೆಕೆರೆ number 6.
ಒಳ್ಳೆಕೆರೆ. ಹಾ,
ಅವ್ರಿಗೆ 2005 ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
2005. ಹಾ,
ನೆಕ್ಸ್ಟ್ ಪೇಜ್
ಅವ್ರಿಗೆ ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅದೇ 2005 ಅಲ್ಲಿ ಮೊದಲನೇ ಅವಧಿಗೆ 2010 ಅಲ್ಲಿ ಮೊದಲನೇ ಅವಧಿ
ಸೀರಿಯಲ್ ನಂಬರ್
29.
ಹಾ.
2010 ಅಲ್ಲಿ first term ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವ್ರದ್ದು ಕಂಟೆನ್ಷನ್ ಏನು ಅಂತಂದ್ರೆ, ನಮ್ಗೆ ಹಿಂದೆ ಮಹಿಳೆ ಇದ್ದಾಗ ಮಹಿಳೆ ಕೂಡ ಬರುತ್ತಲ್ಲ ಅಂತ. ಆದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅವ್ರಿಗೆ ಸಾಮಾನ್ಯ ಮಹಿಳೆ ಇರುತ್ತೆ. ಅವರು ಹಿಂದೆ ಉತ್ತರ ಕೊಟ್ಟಿದ್ದಾರೆ. 2010 ಅಲ್ಲಿ ಈಗಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಸ್ ಮೇಡಮ್. ಅಲ್ಲ, ಅದನ್ನೇ ಹೇಳ್ತಾರದು ಅವರು. ಒನ್ಸ್ ಕ್ಯಾಟಗರಿ BCA ವಾಸ್ ಗಿವನ್, ನೋ ಡೌಟ್, ಬಟ್ ನೆವರ್ ಫಾರ್ BCA ವುಮನ್. ಆದ್ರೆ ಬೇರೆದ್ರಲ್ಲಿ BCA ವುಮನ್ನೇ ಕೊಟ್ಟಿದ್ದು ಮತ್ತೆ ಮತ್ತೆ ಅಲ್ಲೇ ರಿಪೀಟ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಆಮೇಲೆ ದಿ ಓನ್ಲಿ ಕಂಟೆನ್ಷನ್ ವಿಚ್ ಇಸ್ ಪುಟ್ ಫೋರ್ತ್ ಈಸ್ ಫ್ರಮ್ ಯುವರ್ ಸೈಡ್. ಪ್ರೀವಿಯಸ್ ಟರ್ಮ್ ದಿ ಪೋಸ್ಟ್ ಆಫ್ ಅಧ್ಯಕ್ಷ ವಾಸ್ ರಿಸರ್ವ್ಡ್ ಫಾರ್ ಎ ವುಮನ್ ಅಂಡ್ ದೇರ್ ಫೋರ್ ದಿಸ್ ಟೈಮ್ ಇಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಗಿವನ್. ಬಟ್ ನೀವು ಕೊಟ್ಟಿರೋ ರಿಸರ್ವೇಶನ್ ನೋಡಿದ್ರು ಕೂಡ ಆಸ್ ಇಸ್ ಪಾಯಿಂಟೆಡ್ ಔಟ್ ಫ್ರಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3. ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ವಾಸ್ ಜನರಲ್ ವುಮನ್, ದಿಸ್ ಟೈಮ್ ಅಗೇನ್ ಇಟ್ ಇಸ್ BCA ವುಮನ್. ಇಫ್ ದಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಸ್ ಟು ಬಿ ಪುಟ್ ಫಾರ್, why this constitution should be deprived of BCA woman anta, because it has never got. Correct, BCA woman has never come. ಆದ್ರೆ ಮಿಕ್ಕಿದ್ದಕ್ಕೆ BCA ವುಮನ್ ಮುಂಚೆನೂ ಬಂದಿದ್ದು ಕೂಡ ಮತ್ತೆನೆ ರಿಪೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಅಂಡ್ ದಿ ಸೇಮ್ ಅನಾಲಜಿ ಇಫ್ ದಟ್ ಇಸ್ ಟು ಬಿ ಅಪ್ಲೈಡ್, ಇವಾಗ ಇದಕ್ಕೆ ಹಿರಿಕಳಲೆಗೆ ಸಿನ್ಸ್ 2010 ಸೆಕೆಂಡ್ ಟರ್ಮ್ BCA ವುಮನ್ ವಾಸ್ ಗಿವನ್. ಸೆಕೆಂಡ್ ಟರ್ಮ್ BCA ವುಮನ್. ಇವ್ರಿಗೆ ಒಂದ್ಸರಿನೂ ಬಂದಿಲ್ಲ, ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದವ್ರು. ಸರಿ, ದಟ್ಸ್ ಆಲ್ ರೈಟ್.
ರಿಪೀಟ್ ಮಾಡಿದವ್ರಿಗೆ ರಿಪೀಟ್ ಮಾಡ್ತಾರೆ. ಎಂತಲೂ ಒಂದೇ ನೋಡ್ಕೆ ಇಲ್ಲ.
ಇವಾಗ ಹಿರಿಕಳಲೆಗೆ BCA ಮಾಡಿ ಇವ್ರಿಗೆ BCA ವುಮನ್ ಮಾಡ್ಬೋದಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 3. ಅದು ಅಲ್ಲದೆ ಪ್ರೀವಿಯಸ್ ಟರ್ಮು ಜನರಲ್ ವುಮನ್ ಕೊಟ್ಟಿದ್ರು ಅವ್ರಿಗೆ. ಸೊ ಅಗೇನ್ ಇಟ್ ಬಿ ವುಮನ್. ಅದು BCA ಮಾಡಿದ್ರೆ ಇಟ್ ವಿಲ್ ಮೀಟ್ ಬೋತ್ ದಿ ರಿಕ್ವೈರ್ಮೆಂಟ್ಸ್. ಅವ್ರಿಗೆ ಒಂದ್ಸರಿ, ಇವ್ರಿಗೆ ಒಂದ್ಸರಿನೂ ಬಂದಿಲ್ಲ. that will also be against that principles. That if the previous term it is reserved for women, this time it should not be reserved anta. Correct. So ivrige SC woman ಆಗಿತ್ತು last time. ವಿಠಲ ಬರ್ತಾನೆ SC woman. ಏನಪ್ಪ ನನಗೆ by this all these relevant factors are not fed into the computers. ಅಲ್ಲ ಕಂಟೆಸ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತಲ್ಲ, ದಟ್ ಇಸ್ ವಾಟ್. ಯಾಕೆ ಕಷ್ಟ ಆಗುತ್ತೆ? ಅಲ್ಲ, all that comes with a rider as far as possible anta. That is why you will find so many repetition. ಅಲ್ಲ, ಹಂಗ್ ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಹಂಗ್ ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ನೀವು ನಿಮ್ ಕೈಲೇ ತಂದು ಪೇಪರ್ಸ್ ಕೊಟ್ರು ಕೂಡ you will find it difficult. That's why I am telling you. You see, you can have a general guidelines. ಏನಾಗುತ್ತೆ, there are so many factors. Now you take the example of this KRPete, 37 constituencies, 37 ಗ್ರಾಮ ಪಂಚಾಯತ್, 34 ಕೆಲವು ಕಡೆ ಬರೀ 5-6 ಗ್ರಾಮ ಪಂಚಾಯತ್. ಈ ತರ there are so many factors. ಹೌದು, ಅದಕ್ಕೇನೆ everywhere they have used this word as far as possible. Rotation has to be done. There is no doubt about it. Rotation has to be done. Correct. Information is only fed there. Yes.
At that time, when you are reading the computer, it should be taken note of and they have to add this thing. ABCD alphabetical ಪ್ರಕಾರ they have to add it. ಅವಾಗ ತಾಲೂಕು ವೈಸಲ್ಲಿ 25 ಅವಾಗ ಕಂಪ್ಲೀಟ್ ಮಾಡಬಹುದು.
ಇದ್ರಲ್ಲ ಚೆಕ್ ಮಾಡಿ ನೋಡ್ರಮ್ಮ ನೀವು. You please check it with the video recording. If the system is done in such a way that it will take all these things, all these factors into consideration. That earlier BCA woman reservation was never given. ಬೇರೆ ಕಡೆಗೆ ಈ ಹಿರಿಕಡಲೆ ಅಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಈ ಫ್ಯಾಕ್ಟರ್ ನ why it is not taking, ಅಥವಾ if it has taken into consideration and it has come up with the result and thereafter it is changed, then therefore ಅಲ್ಲ ಇವ್ರ ಅಲಿಗೇಷನ್ ಇಲ್ಲ, but we can take note of the submissions made by the learned counsel in the previous writ petition. If that kind of a thing happens, if the computer is fed with all these relevant factors, and if it had put up the result showing this time it should be BCA woman, having regard to the fact that Hirikadale and the other constituencies were earlier given BCA woman, and this time it could be given BCA. ಅದು ಆ ತರ ರಿಸಲ್ಟ್ ಕೊಟ್ಟಿದ್ರು ಕೂಡ ಆಮೇಲೆ ಇವ್ರನ್ನ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ತಪ್ಪಾಗುತ್ತೆ. ಅಲ್ಲ, ಸಿ if according to you the computer application is almost made in a foolproof manner, you cannot, of course it cannot be 100% foolproof. Definitely yes. That is why I said even if you give it to the learned counsel, they will not be able to do it. Not for idu rotation of reservation amongst the gram panchayats. State cannot be taken as a unit, sir. Agadilla, sadhyane illa.
ವಿಡಿಯೋಗ್ರಫಿ ಮಾಡಿಲ್ಲ ವಿಡಿಯೋಗ್ರಫಿ ಮಾಡಿಲ್ಲ ಅಂತ
ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಇದು see, yesterday when we passed one order, there we found more than 3 times they had given that reservation. Idral angilla. Once you only pointed out once earlier it was given. That may not be.
ಕೆಲವು ಪಂಚಾಯತಿಗೆ
ಅದು ಸಾಧ್ಯ, ಅದು ಸಾಧ್ಯ ಇದೆ.
90% ಕೊಟ್ಟಿದ್ದಾರೆ, ಇನ್ನೊಂದು 10 to 8% ಮಾತ್ರ ಕೊಟ್ಟಿಲ್ಲ. ಸಿಕ್ಕಿದಲ್ಲಿ ಇರ್ತಾರೆ
ಆಯ್ತು, ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡಿ. ಸೇಮ್ ಥಿಂಗ್ ಲೈಕ್ ವಾಟ್ ವಿ ಡಿಡ್ ಇನ್ ದಿ ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್. ಅದು ಪ್ರೀವಿಯಸ್ ಯಾರು ಡಿಕ್ರೇಷನ್ ತಗೊಂಡಿದ್ದು ನೀವೇನಾ? ಅಲ್ಲಿ AAG ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, AAG/HCGP ಸೇಮ್ ಆರ್ಡರ್. Have tomorrow. Yes. ಅಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಬರ್ತದೆ. It has been pointed out by learned counsel for petitioner that in the case of Hirikadale Gram Panchayat, though reservation was provided to the post of Adhyaksha in the category of PCA woman in the year 2010 bracket ali second term, again PCA woman reservation is given. So, however, insofar as Vittalapura is concerned, PCA woman reservation was never given.
See.
ಅಲ್ಲ ರೀ, ಲಾಸ್ಟ್ ಟೈಮ್ ನಿನ್ ಪ್ರೆಸೆನ್ಸ್ ಎಲ್ಲ ತಾನೆ ಮಾಡಿರೋದು, ಮತ್ತೆ ರೀಕೌಂಟಿಂಗ್ ಅವ್ರು ಇದ್ರಲ್ಲಿ ಮಾಡಿಲ್ವಾ? Our 2:30 we will change it. ನೋಡೋಣ ಇರಿ ಸರ್, ಇವಾಗ ಆಗೋದಿಲ್ಲ. 2:30 will change.
My lord, may I mention for serial number 26? Excuse me, court officer, sir. Excuse me, court officer. Excuse me, court officer.
ಹೇಳಿ ಮೇಡಮ್.
Sir, serial number 26, so the list one call out ಆಗ್ಲಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಲಿಸ್ಟ್ 2 ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ 1 ಇದೆ.
ಮಧ್ಯಾಹ್ನನಾ?
ಮಧ್ಯಾಹ್ನ.
Okay, sir. Thank you.
serial number 4 and list number. Then 19 to the 18 should be
When is the election? We have it on 17th. 17th.
They can't allow anybody to come to the resort of them.
What was the exercise undertaken now? Change. The AG submits that the original ballot papers been furnished by the returning officer. So, the learned counsel for the petitioner. So what did we find on going through that ballot paper? No, Papa. For what reason did I ask you to go and verify it yourself? What was the
now they are reduced towards to me and no they are now one two they are reduced they are not used. One sheet is given, both are getting equal votes. That is wrong. That's the problem. We see the case to consider getting to open in front of us.
Since both the contesting parties are not happy with the results sought to be declared now, that both of them have got equal votes, the ballot papers are directed to be returned to the returning officer. Stop. The parties herein are directed to appear before the returning officer. Yaru Tahsildara? Tahsildar. On 17th of July 2023 at 11 AM. Stop. The returning officer bar Tahsildar shall count the votes in the presence of the parties. Huh? Stop. The learned counsels representing the parties may also be permitted to be present during the recounting. Full stop. Next para. Any objection raised by any of the parties shall be recorded by the returning officer or Tahsildar. Full stop. Thereafter, the results of the recounting shall once again be forwarded to this court. Stop. Release this matter on 21st of July. ಅಲ್ಲ ಅವರೇ ಇರ್ತಾರಲ್ಲ ಮತ್ತೆ ಇನ್ನೇನು. The returning officer or Tahsildar shall video record the entire proceedings. Entry model. Entry model granted earlier stands extended in next date. At 24. ಯಾವುದು ತಗೊಳಕ್ಕಾಗಲ್ಲ ಬಿಡಿ, ನೀವು ನೋಡ್ತಾ ಇದೀರಲ್ಲ, ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ದೇರ್, ಯು ವಿಲ್ ನಾಟ್ ಬಿ ಏಬಲ್ ಟು ಟೇಕ್ ಎನಿ ಅದರ್ ಮ್ಯಾಟರ್. Yes, that will be done in the end. Yes.
Number 2 continuation. Number 30.
Huh? ಚೆಕ್ ಲಿಸ್ಟ್ ನೀವೇ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ನಂತರ 20ರಿಂದ 2ನೇ ಅವಧಿಯಲ್ಲಿ ಎಸ್ಸಿ ಮಹಿಳಾ ಮೀಸಲಾತಿಯನ್ನು ಜಾರಿ ಮಾಡಿದ್ದೀರಿ. ಕಾನೂನಿನ ಪ್ರಕಾರ ಪ್ರದೇಶ ಪ್ರಕಾರ ಒಂದು ಬಾರಿ ಮಹಿಳೆಯರಿಗೆ ಮತ್ತು ಬಾರಿ ಎಲ್ಲರಿಗೂ ಮೀಸಲಾತಿ ನಿಗದಿಪಡಿಸಬೇಕು. ಆದರೆ ತಾವು 2 ಬಾರಿ ಎಸ್ಸಿ ಮಹಿಳೆಯರಿಗೆ ಅವಕಾಶ ಮೊದಲಿಗೆ 2020ರ 1ನೇ ಅವಧಿಯ ಉಪಾಧ್ಯಕ್ಷರ ರಿಸರ್ವೇಷನ್ ಮಹಿಳಾ ಮೀಸಲಾತಿ ನೀಡಿ ಅವರಿಗೆ ಅವಕಾಶ ನೀಡುತ್ತೀರಿ. 2015ರ ಅವಧಿಯಲ್ಲಿ ಮತ್ತು 2020ರ 2 ಅವಧಿಯಲ್ಲಿ ಅಧ್ಯಕ್ಷರ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಮೀಸಲಾತಿಯನ್ನು ಎಸ್ಸಿ ಮಹಿಳಾ ಮೀಸಲಾತಿ ನೀಡಿ ಮಹಿಳೆಯರಿಗೆ ಮಾತ್ರ ಅವಕಾಶ ನೀಡುತ್ತೀರಿ. ಆದ್ದರಿಂದ 3 ಅವಧಿಯಲ್ಲಿ ಎಸ್ಸಿ ಮೀಸಲಾತಿಯನ್ನು ನೀಡುವುದಿಲ್ಲ. ತಾಲೂಕಿನಲ್ಲಿ ಕೆಲವು ಪಂಚಾಯತ್ಗಳಿಗೆ 2ನೇ ಬಾರಿ ಎಸ್ಸಿ ಮೀಸಲಾತಿಯನ್ನು ನೀಡುತ್ತೀರಿ. ಆದ್ದರಿಂದ ನಾವು 2020ರ 2ನೇ 2021 ಅವಧಿಗೆ ಅಧ್ಯಕ್ಷರ ರಿಸರ್ವೇಷನ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆರ್ಡರ್ನಲ್ಲಿ ಎಸ್ಸಿ ಮೀಸಲಾತಿಗೆ ಆದೇಶ ಮಾಡಿದ್ದಾರೆ.
ಯಾವುದು ಗ್ರಾಮ ಪಂಚಾಯತ್? ಬಳ್ಳೂರು ಈ ಸರಿ ಯಾವ್ದು ಕೊಟ್ಟಿದಾರ?
ಈ ಸರಿ ಎಸ್ಸಿ ನಾವು ಎಸ್ಸಿ ಕುಡಿಯೋದಕ್ಕೆ ಎಸ್ಸಿ ಕೊಟ್ಟರೆ ಆಲ್ರೆಡಿ 2 ಸರಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ಈಗ ಎಸ್ಸಿ ಕೊಟ್ಟರೆ ಬೋತ್ ಇನ್ ಕಂಟೆಸ್ಟೆಂಟ್, ಬೋತ್ ಫೀಮೇಲ್ ಅಂಡ್ ಮೇಲ್ ಕಂಟೆಸ್ಟೆಂಟ್ ಕೊಡ್ತಾರೆ. ಇದು ಬೇರೆ ಬೇರೆ ಪಂಚಾಯತಿಗೆ ಶಿಫ್ಟ್ ಮಾಡಬಹುದು ಅನ್ನೋದು ಪೇಜ್ 9 ಅಲ್ಲಿ SC SC ಎರಡು ಕಡೆ ಕೊಟ್ಟಿದ್ದಾರೆ, 2 ಸಾರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕ್ಲಾಸ್ ಪುಸ್ತಕ ಪೇಜ್ 9 ನೆಕ್ಸ್ಟ್ ಕ್ಲಾಸ್ ನಂಬರ್ 5 ಇದರಲ್ಲಿ 2000 SC ಕೊಟ್ಟಿದ್ದಾರೆ, 2015 SC ಕೊಟ್ಟಿದ್ದಾರೆ, 2023 SC ಫಿಮೇಲ್ ಕೊಡ್ಬೋದಾಗಿದೆ, ಹಂಗೆ SC ಕೊಡ್ಬೋದಾಗಿದೆ. Another one, page 11, then added 821. Then added page 21. 93 ನಲ್ಲಿ SC ಕೊಟ್ಟಿದ್ದಾರೆ, 2010 ನಲ್ಲಿ SC ಫಿಮೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ, 2010 ನಲ್ಲಿ SC ಫಿಮೇಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ, 2015 ನಲ್ಲಿ SC ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ಎರಡು ಕಡೆ SC ಬಂತು, ಈ SC ಫಿಮೇಲ್ ಕೊಡಬಹುದಾಗಿದೆ. Either the male or female is content to SC candidate because of this reservation. That's why we gave an objection to reconsider this. 2 times, 3 times SC female get portrayed. Please reserve it and shift this reservation to another constituency wherever SC female is not given. SC female ಒಂದೇ ಸರಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಂದೇ ಅಲ್ಲಿ ಕೊಡ್ಬೋದಾಗಿತ್ತು. SC 2 ಸಾರಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಫಿಮೇಲ್ 1 ಸಾರಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವುದು ಅಂದೇನಹಳ್ಳಿ
SC ಫಿಮೇಲ್
ಸೀರಿಯಲ್ ನಂಬರ್
21 page 11 ಅಲ್ಲಿ SC ಫಿಮೇಲ್ 2 ಸಾರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. SC ಫಿಮೇಲ್ ಕೊಡ್ಬೋದಾಗಿತ್ತು 2023. SC ಕೊಟ್ಟಿದ್ದಾರೆ, SC ಕೊಟ್ಟಿದ್ದಾರೆ, SC 2 ಕಡೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ದುರಂತ ಇದೆಯಾ? in respect of item number 5 ಕೊಡ್ಬೋದಾಗಿದೆ. then to SC ಫಿಮೇಲ್ 1 ಸಾರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಮ್ಮಲ್ಲಿ ರಿಪೀಟ್ ಆಗಿದೆ SC ಫಿಮೇಲ್ SC ಫಿಮೇಲ್ SC ಫಿಮೇಲ್ ಸರ್. One post for SC female. If we terms that we can't use reservation, the SC category. They are asking instead of SC female, you use the SC.
Yes, what do you say? ಅದೇ ಇದು we had considered this purport. Yes. Yes. ಹಾ.
ಅವಧಿಗಳು serial number 5, not in serial number 2. Serial number 4 is ಹಿಂದಿನ ಅವಧಿ, previous term. ಹಿಂದಿನ ಅವಧಿಯಲ್ಲಿ ಜಿಲ್ಲಾ ಅಧ್ಯಕ್ಷರು there are totally 30 Telecast.
ಎರಡೂ ಇದೆ. ಎರಡೂ ಇದೆ. ಎರಡೂ ಇದೆ. ಎರಡೂನು ದೆಟ್ಟದು. ಎರಡೂನು they have to take into consideration. ಎರಡ್ ಸರಿನು ಎರಡ್ ತರನು ಇದೆ. Yes.
ಹೀಗೆ ಮಾಡುವಾಗ ಸಾಧ್ಯವಾದಷ್ಟು ಮಟ್ಟಿಗೆ ಹಿಂದಿನ ಅವಧಿಯಲ್ಲಿ ಮಹಿಳಾ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಹುದ್ದೆಗಳನ್ನು ಪಡೆದಿದ್ದ ಆಲ್ರೆಡಿ ಪಡೆದಿದ್ದ such ಗ್ರಾಮ ಪಂಚಾಯತ್ಗಳನ್ನು ಹೊರತುಪಡಿಸತಕ್ಕಂಥ it should be excluded from that ಅಂತ next
therefore ಎರಡೂ ಇದೆ. ಎರಡೂ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ಎರಡೂನು ಗಣನೆಗೆ ತಗೋಬೇಕಾಗುತ್ತೆ. Yes. Yes. Yes.
There is a specific difference between 4 and 5. Avadhi and avadhi. How many of the candidates at least 5 points? Please there are totally 13 Telecast seats. And now it is allotted to 13 panchayat members. It starts with checklist members and kindly see number 5.
ಅದೇ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು 2015 for entire 5 years term it was SC. No, that's all right, but these are the factors that were required to be taken into consideration. Yes. Yes.
General field. May not come to serial number 6. No, the general has come. Not may kindly see the previous term. The general field. Not may now kindly come to serial number 8. Further there. SC general has come.
Hmm.
Previous term, my lord, general period. Lord, may now kindly turn to serial number 11, CH-10.
Hmm.
Imamla.
Hmm.
Imamla, SC woman. My lord, may see the previous general. There is no woman. That's why SC woman is visible. My lord, may now kindly turn to serial number 12.
Hmm.
Then for general in 20. How SC woman has come. My lord, may kindly come. Neradu, SC female had come in 2020. This time it has come for SC general. First for female SC general. Now my lord, may kindly come to Madhu, previous of the petition. First general, as in the earlier general category, it has fallen to SC female. And the previous of the petition member SC has not come. SC female. Regular religion. My lord, may kindly come back. 2020 first from SC, 2010 first from SC. Twice that it has come. And SC female has come only once in 2015. In the error series, he considered movement and SC again. Movement and SC general committee. Now page 21. I'm just pointing out where SC has come. Let me see 2020 general female. So SC general has come. General has come 2020. So SCW has SC female. My lord, next my lord, general female roles and 2020 first. I think that's the MRS, general 2020. So SCW has come. General SCW. He has come to Balloon, direction is only there. See, female, once and three, that is because last time it was general. Totally 50% is unable. General is 50, SC is 50. You have to divide on 50. They cannot mean that SC female has come more than SC has come. Director not give SC to them. SC movement very convenient.
What agreements? 2 SC, 2 SC female. Now SC has come in this 2023.
ಅಲ್ಲ ಇದು BCA ಕ್ಯಾಟಗರಿ ಇದೆ ಇದರಲ್ಲಿ.
State as divide and district wise divide. 50% is the
BCMA and BCMB. 28%.
ಆಯ್ತು. So to maintain it at 50%. That is why there is no reservation given for BCA, BCB. Alama, but if you see this annexure A, you put a checklist annexure A and Takida. If you see, they have simply reversed what was there earlier. In almost all the Gram Panchayat, they have simply reversed it. They will never get SC then. No, the 2 terms ago, in all these categories, they have got the same reservation. Iವಾಗ ಯಾರ್ಯಾರಿಗೆ SC ಕೊಟ್ಟಿದಿರೋ 2 terms ago they had got SC only. ಅದನ್ನ ಅವ್ರು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತಾ ಇರೋದು. Why that is being done? Only because you are saying, because in the previous term ಜನರಲ್ ಫೀಮೇಲ್ ಕೊಟ್ಟಿದ್ರಿಂದ ಈ ಸರಿ ಫೀಮೇಲ್ ಕೊಡಬಾರ್ದು ಅಂದ್ಬಿಟ್ಟು SC ಮಾಡಿದ್ದೀರಾ ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇರೋದು. But then there are so many relevant factors that are not being taken into consideration. Illa. What you read out now gives a very clear direction that as far as possible, ನೀವು ಪ್ರೀವಿಯಸ್ ಬಾರ್ ಅದೇನೋ ಓದಿದ್ರಲ್ಲ ನೀವು
It comes to someone the software, so that it keeps email in the previous category of development. When it starts allocating to SC and SK, it is coming off of general and then it is. So only explanation because it has happened to everybody.
ಬೇರೆದ್ರಲ್ಲೂ ಬಂದಿದೆ ಆ ತರ. It is not that will not be a one-off case. ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅದೇ ತರ ಆಗಿದೆ. ಇವಾಗ ಹಂಗ್ ನೋಡಿದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಬ್ಯಾಗಟ್ ದೇವನಹಳ್ಳಿ, it is the third time they are getting SC. The same argument can be held against them also. Huh? ಅಲ್ಲ ನೀವು as you said, ಇಲ್ಲಿ for the entire thing I think only 1 or 2 posts for ST is given, only 1. So ಮಿಕ್ಕಿದೆಲ್ಲ SC ನೇ. Therefore what was the difficulty in taking into consideration the fact that earlier in 2015 SC female only was given. Correct. So therefore some important factors that were required to be considered has not been taken into consideration.
Serial number 19
ನಿಮ್ದು ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್?
serial number 19.
ಅದೇ ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್?
Serial number 26 and 27. ಮುಗುಳುಗೂ ಆಮೇಲೆ ನೆರೆಯು.
ಮುಗುಳೂರಿಗೆ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ? ಅದೇ ಎಲ್ಲ ರಿವರ್ಸ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ.
SC 2 ಸಲ ಬಂದಿದೆ, SC ವುಮನ್ 2 ಸಲ ಬಂದಿದೆ.
ಅಲ್ಲ ಮುಗುಳೂರಿಗೆ ಇವಾಗ SC ವುಮನ್ ಕೊಟ್ಟಿದಾರಾ? ಆಮೇಲೆ ಅಲ್ಲಲ್ಲ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಇವಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಮೋಸ್ಟ್ಲಿ ಜನರಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ನೋಡಿ, ಜನರಲ್ ಎರಡೂ ಜನರಲ್. ಎಲ್ಲ ಈಗ ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲ ನಾವು ದಿ learned additional advocate general read out the guideline why BCA BCB has not been given any reservation ಅನ್ನೋದಕ್ಕೆ the requirement is, you see the first page of the guideline, it was just now read out. Paragraph number 4 and 5 ಓದಿದ್ರು. It says, since the reservation should not exceed 50%, wherever the reservation is exceeding 50%, ಅಲ್ಲಿ ಸಾಧ್ಯವಾದಷ್ಟು SC ST ಗಳಿಗೆ ರಿಟೈನ್ ಮಾಡಿಕೊಂಡು ಬೇರೆ ಕಡೆಗೆ you shift this BCA BCB reservation to some other constituencies. So therefore ಅಲ್ಲ ಮಾಡಿದಾರಲ್ಲ. ಅಲ್ಲ I do not know whether you are challenging the guidelines. You are challenging the guidelines.
Should not exceed 50%.
Yes.
After giving reservation for SC ST, including the other, include my 50% target.
Yes.
Akasmat SC ST reservation ಕೊಟ್ಟಾದ ನಂತರ if it remains, ಆವಾಗ backward class. ಈಗ ಹೇಳೋದು ನಂಬರ್ ಅನ್ನ
state wise determine ಮಾಡಿದ್ದೀವಿ. I have understood my relatives are interested. They say total number of posts for SC, for ST, for backward class is determined, is required to be determined. They should determine it only state wise. So Karnataka total 5,800 ಗ್ರಾಮ ಪಂಚಾಯತ್ ಎಫ್ಒ ಅದಷ್ಟು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನದಲ್ಲಿ SC, ST ಬರುತ್ತೆ. ತಾಲೂಕಿನಲ್ಲಿ ಅಲ್ಲ. ಟೋಟಲ್ ಅಲ್ಲಿ ಅಷ್ಟು ಮಾಡಿದಾಗ 50% ಎಕ್ಸ್ಟ್ರಾ ಏನು ಉಳಿಯುತ್ತೆ ದಟ್ ಶುಡ್ ಗೋ ಟು PCA, PCB ಅವಕ್ಕೆ ಕೊಡೋದಕ್ಕೆ ಅವಕಾಶ ಇದೆ. ಅದು ನಾಟ್ ನಮ್ಮ ಪಂಚಾಯತ್ ವೈಸ್, ದಟ್ ಈಸ್ ಸ್ಟೇಟ್ ವೈಸ್ ಎಷ್ಟು ಬರುತ್ತೆ. ಆಮೇಲೆ ಇವರು ಈ ಸಲ ಸಬ್ಜೆಕ್ಟ್ ನಾನು ಇಲೆಕ್ಷನ್ ನಿಲ್ಲಿಸಬೇಕು ಅಂತ ನಮ್ಮ ಮನಸ್ಸಿಂದ ಇದಕ್ಕೆ ಆಗಿಬಿಟ್ಟಿಲ್ಲ ಪೂರಾ ಹೋಗ್ತಾರೆ. ಈ ರೀತಿ ತಾಲೂಕಿಗೆ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡೋದು ಮಾಡ್ತಾರೆ. ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಪ್ರಾಕ್ಟಿಕಲ್ ಸಿಚುವೇಶನ್ ಇದೆ ಮಾಡ್ತಾರೆ ಅಂತ ಎಲ್ಲಾ ತಾಲೂಕಿನಲ್ಲಿ ಬರ್ಬೇಕು, PCA ಬರ್ಬೇಕು, ಸ್ಟೇಟ್ ವೈಸ್ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ. ನಾನು ಸ್ಟೇಟ್ ವೈಸ್ PCA ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ಮೊದಲಿನ 10 ತಾಲೂಕು ತಾವು ಮುಂದೋಡ್ಬಿಟ್ಟು ಇನ್ನು ಮುಂದೋಡಿ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇದೆ. ಒಂದ್ಸಲ they want to subdivide it ತಾಲೂಕು ವೈಸ್. Subdivision is complicated.
We will do one thing.
ಈ ಅನೇಕ ತಾಲೂಕಿನಲ್ಲಿ as the things stand ಅವರು
Correct.
सुनवाई होगी तो उन्होंने बात कर दी 471 लोगों को है।
सीरियल नंबर 19 see page 83. ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸ್ ಇಂದಿಲ್ಲ
ಗೊತ್ತಾಯ್ತು. It was
ಅದೇ
submitted.
page 98 ಅದು ಹೋದ ಸಲ ಇದು ಈ ಸಲ 98 ಈ ಸಲ ಎಲ್ಲೂ ಇದೆ. ಅಂದ್ರೆ ಆನೇಕಲ್ ತಾಲೂಕಿಗೆ ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸ್ ರಿಸರ್ವೇಶನ್ ಬರೋದಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಕಾರಣ ಹಾಗಾದ್ರೆ SC ST ಅಪ್ಲೈ ಕೊಡ್ತೀವಿ ತಾಲೂಕು ವೈಸ್ ಲೆಕ್ಕ ಮಾಡೋದಾದ್ರೆ. ಆಮೇಲೆ ಅದು ನಾವು ಈಗಾಗಲೇ ಆಲ್ರೆಡಿ ಪಾಯಿಂಟೆಡ್ ಏನಿಲ್ಲ page 186 random ಮಾಡಿದವಿ ಕಂಪ್ಯೂಟರ್ ನಿಂದ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಬರಲ್ಲ. that may not be a either you feed ಮಾಡಿರೋದೇ wrong ಇಲ್ಲ ಅಂದ್ರೆ ಆ ಮಿಸ್ಟೇಕ್ ಆಗುತ್ತೆ. 26 page 186 1993 ಇಂದ ಯಾವಾಗ ಆಫೀಸಸ್ ಯಾರಿಗೆ ರಿಸರ್ವ್ ಆಗಿದೆ ಅನ್ನೋದು ಸೀರಿಯಲ್ ನಂಬರ್ 8 ನೋಡಿ. Page 186 connection F1
ಅಲ್ಲ ಇದೆ ಇದೆಲ್ಲ ಇವ್ರದ್ದು ಚೆಕ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
SC ಸಲ ಅಂದ್ರೆ ಈ ಸಲ ಮುಂದೆ SC ವುಮನ್ ಒಂದು ಬಂದಿದೆ. ಮುಂದೆ ಎಲ್ಲವೂ SC ಒಂದ್ಸಲ 2 ಸಲ 3ನೇ ಸಲ ಬಂದಿದೆ.
ಅಲ್ಲ ಇವಾಗ ನಿಮ್ಮ ಪೆಟಿಷನ್ ನಲ್ಲಿ ಯುವರ್ ಮೇನ್ ಗ್ರೀವೆನ್ಸ್ ಈಸ್ ದಟ್ ರಿಸರ್ವೇಶನ್ ಫಾರ್ BCA, BCB was required to be given, it is not given.
So, contention, we have taken a contention. It can only be state-wise number determined. State-wise allowed. For a moment, let us assume, because of that guideline, they have fixed the number state-wise, but subdivided it thoroughly. I don't think that they can say.
But is it the same thing that was done even previously also? I don't think because ನಿಮ್ಮ the list ನೋಡಿದ್ರೆ never ever they have given till 2010 ಅದಾದ್ಮೇಲೆ ಕೊಟ್ಟಿಲ್ಲ 2010 ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅಷ್ಟೇ ಅದಾದ್ಮೇಲೆ 2015 ಅಲ್ಲಿ ಇಲ್ಲ 2020 ಇಲ್ಲ ಸೊ ಯು ಆರ್ ನಾಟ್ ಚಾಲೆಂಜ್ ದಟ್ ಒನ್ ಇಲ್ಲ ಅವಾಗ್ಲೂ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ 2015 ಅಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ 2020 ಫಸ್ಟ್ ಟರ್ಮ್ ಅಲ್ಲೂ ಕೊಟ್ಟಿಲ್ಲ ಸೊ ಫಾರ್ ದಿ ಫಸ್ಟ್ ಟೈಮ್ ಯು ಆರ್ ಚಾಲೆಂಜಿಂಗ್ ದಿಸ್ ಒನ್
I would say something against my case itself. ಇಲ್ಲ ಈ ಕ್ವಶನ್ ನೀವು ರೇಸ್ ಮಾಡಿದ್ರೆ ನಾವು ಸ್ಟೇಟ್ ವೈಡ್ ಇಲೆಕ್ಷನ್ ಬಂದ್ ಮಾಡಬೇಕಾಗುತ್ತೆ ಹಂಗಾಗುದಿಲ್ಲ ಹಿಂಗಾಗುದಿಲ್ಲ.
So therefore that is what I was thinking was
ಅದಕ್ಕಾಗಿ ಈ ಸ್ಟೇಜ್ ಒಳಗೆ ಅದನ್ನ ಮಾಡೋದಿಲ್ಲ ನಾವು ವಿಚಾರಣೆ ಮಾಡೋದಾದ್ರೆ ಪೊಲೀಸ್ ಮಾಡಿ ಇಟ್ಬಿಡ್ತೀನಿ ಯಾವಾಗ ವಿಚಾರಣೆ ಆಗಲಿ ಅಂತೇಳಿ ಹೇಳೋ ಸಾಧ್ಯತೆ ಇದೆ. ಐ ನೋ ದಟ್ ಇಸ್ ಮೈ ಆನ್ಸರ್. ಸಬ್ಡಿವೈಡಿಂಗ್ ಇಟ್ ಇಂಟು ತಾಲೂಕಾಸ್ ರಿಸರ್ವೇಷನ್ ಯಾಕಂದ್ರೆ ಅವಾಗ ಪಾಪ್ಯುಲೇಷನ್ ಮೇಲೆ ಮಾಡ್ತಾ ಇಲ್ಲ ತಾವು ಆ ಟೈಮಿಗೆ ಪಾಪ್ಯುಲೇಷನ್ ಮೇಲೆ ಮಾಡ್ತಾ ಇಲ್ಲ ಆ ಟೈಮಿಗೆ ಸ್ಟೇಟ್ ವೈಸ್ ಎಲ್ಲಾ ಪಂಚಾಯತ್ಗಳಿಗೂ ರಿಸರ್ವೇಷನ್ ಅನ್ನ ಸಬ್ಡಿವೈಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಪಾಪ್ಯುಲೇಷನ್ ತಗೊಂಡು ಇಂಥ ಪಂಚಾಯತ್ ಏರಿಯಾದಲ್ಲಿ SC ಪಾಪ್ಯುಲೇಷನ್ ಇಷ್ಟೈತಿ ಅದಕ್ಕಾಗಿ ಕೊಡ್ತೇವೆ ಅಂತ ಮತ್ತೆ ಅದನ್ನೇ what paragraph that totally a misconception that ಯಾವ ಪಂಚಾಯತ್ ಒಳಗೆ ಎಷ್ಟು ನಂಬರ್ ಆಫ್ SC ಸೀಟ್ ಅಥವಾ ST ಸೀಟ್ ಆರಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಅದರ ಪ್ರಮಾಣದಲ್ಲಿ ನಾವು ಅಲಾಟ್ ಮಾಡ್ತೇವೆ. That is not something constitutionally or statutorily permissible. Each taluk should get whatever is the quota available. Each taluk should get. I can understand they may come up with a case. BCP woman in all that we have is only 600. There are 5,000 in our Gram Panchayat. Therefore, it is not possible to give it to PC1P now. Then they will have to say, for these years we have given it to this set of talukas. Now, next, this set of talukas have been given. It will reach Anekal also when we come to the next set. Or now, there should be some rational basis, even for, let us say, the question of subdivision is not correct, is left out. For a moment, assuming it is to be done, it cannot be in this way. ಆಮೇಲೆ ತಾಲೂಕು ವಹಿಸಿ SC ನೋಡಿ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ ಹೇಳೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. ಯಾಕಂದ್ರೆ ನೀವು ಫಿಕ್ಸ್ ಮಾಡಿರೋದು ಸ್ಟೇಟ್ ವೈಸ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ತಾಲೂಕಿಗೂ ಹೋಗಿ ಸಪೋಸ್ ಯಾವುದೋ ಒಂದು ರಿಸರ್ವೇಷನ್ ನಂಬರ್ ಎಕ್ಸೆಲ್ ಇಸ್ 600 5,000 ಪಂಚಾಯತ್. Yes, first 93 we have selected these 600. Next 90 election, next 600. Like that, we have to do. Ultimately, what is important is the reason of giving reservation is for social justice and therefore it should reach everyone. Protection we would provide. This contention that backward class reservation will not come because we have allotted more number of SC/ST seats to you. It will now increase to more than 50%. Otherwise, it's not available.
all right, see, but if you are pressing on the question of not providing reservation to backward classes in Anekal Taluk, that is a question that can be decided only after a complete hearing. So no interim order can be passed at this stage.
How you will
will have to, even at this stage, because the new notification is sure. Even at this stage, they will have to come up with the number of backward class reservation they have fixed statewide and how they have distributed. Then our here, just saying, election event, now in manual Madita, computer Madita, they cannot test it. This is something which even at this stage, they will have to at least reasonably, ಪ್ರಯತ್ನ ಮಾಡಿ ಈ ಒಂದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಈ ಸಲ ಬಿಟ್ಬಿಡಿ ಅಂತ ಹೇಳೋ ಅಷ್ಟಾದ್ರೂ
See, that way I'm sure they will be having information as to how they have given this backward classes reservation in some of the talukas. ಅದನ್ನ ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು even that has to be rotated. Otherwise, it is possible that many of the taluks will never get. So therefore, to answer your immediate question as to whether they have really given any reservation to backward classes community in the entire state, that much of information will definitely be available with them. I am sure it will be available with them. Yes. Therefore, ಅದನ್ನ ನಾವು you are now raising a challenge that in terms of the constitutional requirement for doing social justice, even that has to be rotated. It cannot be kept stable only to particular talukas.
They are doing. Each of the backward class community is not something that they can do at this stage.
ಅಲ್ಲ ಅಷ್ಟೇನೆ ಆದ್ರೂ ಕೂಡ all this what I am trying to say is at this stage probably in another day or two they are going to announce the calendar of events. Nothing is going to happen after that. Therefore, we will not close these cases. Nimma case especially, where you have raised a challenge to the notification issued by the State Election Commission on the question of providing reservation to backward classes communities. That question will keep it alive. We will decide this issue because this is the second term of the 2020 elections, and this they have maintained from the past from 2005 or 2015. From 2015, they have maintained this policy. Now, ಈಗ ಸಡನ್ ಆಗಿ ಇನ್ನೊಂದು 2 ದಿವಸ ಇರುವಾಗ if I say no, you are not giving a satisfactory answers, ನಾವು I don't think we can do it at this stage. So we will definitely consider this.
Maharashtra election provide them the reservation. Nagpur election announce backward class reservation. Election. Somewhere it should first thing is they don't have any excuse for not training these rules. Every time on some the other guidelines, rules frame it would have come to before saying this is how it happens. Every time, of course, people will wake up only when the election is for different.
Okay, that is why.
But it cannot ಇದನ್ನ ಈ ರೀತಿಯ ಒಂದು ಇದು ಮಾಡೋದಕ್ಕೆ ಆಗೋದು. For
Yes.
Subsection 2. Subject to the general or special order of the state election commission, deputy commissioner shall reserve. So, on the basis of ratio of population to the state, number of panchayat, number of offices available, and such number of offices of Adhyaksha, Upadhyaksha of Gram Panchayats in the state for the scheduled caste and scheduled tribes, and the number of such officers directly as nearly as may be same proportion to the total number of officers in the state and the population of scheduled caste in the state or of the scheduled tribes in the state. That's to the total population of the state. So number 1 and 2, there is no other info but to fix it statements. B. Such number of officers of Adhyaksha and Upadhyaksha of the Gram Panchayat, which shall as nearly as may be 1/3 of the total number of officers of Adhyaksha, Upadhyaksha in the state for the persons belonging to backward classes. The reservation and code more than but this reservation has a limit, that is provided that
next sentence. But the number of officers
but the
BLA.
But under this clause shall be so determined that the total number of officers of Adhyaksha and Upadhyaksha reserved for scheduled caste, scheduled tribes under clause A and the backward classes under this clause shall not exceed 50% of the total number of officers of Adhyaksha, Upadhyaksha of the Gram Panchayats in the state.
Yes.
So ultimately there is a limit put that after the reservation, available reservation on the basis of population for SC and ST, in the remaining, not exceeding 50%, backward class reservation is to be given. That is again stated. A category, B category, it's not of to C argument provided that offices reserved under this subsection shall be rotated by rotation between Gram Panchayats, different talukas. Taluka or subdivision model, RT model, I'm not for postponing the election, therefore, as the logic that could be considered later, that not now and that how here, issue not but the rotation for different Gram Panchayats and what the taluki that is something they will have to correct. Yes, to put that, it is the same thing because it's a constitutional mandate. Provided also that number of offices, Article 243T, provided also that number of offices reserved under this clause shall be allotted by rotation to different panchayats. Taluk-wise model.
But they are doing this because in the previous judgments, the division benches have held how to do this. That is why I think they are making use of that judgments, and they are saying it has to be rotated only within the talukas. I think that is the directions given by the division bench. Allala, rotation has to take place. Sorry. No, that is different. That is different.
But actually, I end to taluk wise something. Of course, at the other case, page 186.
Serial number 13 and 14, you also may change. ಮಂಟಪ ಬನ್ನೇರಡು ಇವರಿಗೆ ಜನರಲ್ ಫೀಮೇಲ್ ಇಲ್ಲಿವರೆಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಲಾಸ್ಟ್ ಕಾಲಮ್ ಪೇಜ್ 186 ಲಾಸ್ಟ್ ಕಾಲಮ್ ನೋಡಿದ್ರೆ ಜನರಲ್ ವುಮನ್ ಇವೆರಡೂ ಇದಕ್ಕೆ ಒಮ್ಮೆಯೂ ಬಂದಿದೆ ಇಲ್ಲಿವರೆಗೆ. ಅದೇ ನರೇಗಾ ತಾವು ಸೀರಿಯಲ್ ನಂಬರ್ 27 ನೋಡಿದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 27 ನರೇಗಾ ನಮಗೆ 3 ಸಲ ಜನರಲ್ ವುಮನ್ ಈ ಸಲ ಜನರಲ್ ವುಮನ್
ಇಂದಲವಾಡಿಗೆ ಬಂದಿದೆ, ಉಸ್ಕೂರ್ಗ್ ಬಂದಿದೆ, ಬಿದರ್ಕುಪ್ಪೆಗೆ ಬಂದಿದೆ. ಅದೇ ಅದೇ ಅಲ್ಲ 3 ಟೈಮ್ಸ್ ಅಲ್ಲಿಗೆ ಬಂದಿದೆ ನೋಡಿ. ಅದೇ ಅದೇ ಅಲ್ಲೂ 3 ಸರಿ ಬಂದಿದೆ ಬಂದಿದ್ದಾರೆ.
ಆಮೇಲೆ ಇಲ್ಲಿ ಈ ಸೀರಿಯಲ್ ನಂಬರ್ 26 and 27 ಇನ್ನೊಂದು ತಾವು SC ರೆಗ್ಯುಲರ್ 2 ಸಲ ಬಂದಿದೆ, SC ವುಮನ್ ಮುಗಳೂರಿಗೆ 2 ಸಲ ಅಂದ್ರೆ ಈ ಸಲ ಬಿಟ್ಟು 2 ಬಂದಿದೆ, ಮತ್ತೆ ನೆರೆಗಕ್ಕೆ 1 ಬಂದಿದೆ. ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ನೋಡಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 8 ನಲ್ಲಿ ಅವರಿಗೆ SC ರೆಗ್ಯುಲರ್ 3 ಸಲ ಬಂದಿದೆ, SC ವುಮನ್ 1 ಬಂದಿದೆ. Existing setup ನಲ್ಲಿ distribution ಮಾಡಿರೋದು ಸಮಯ. Now that there are 4 or 5 of us ಅನೇಕರಿಂದ ಹಾಕಿದವರು ಅದಕ್ಕಾಗಿ ನಾನು ಹೇಳೋದು ಕನ್ಸಲ್ಟ್ ಅಫಿಷಿಯಲ್ ನಾನೇಕಂತ ಆಲೋಚನೆ ಮಾಡೋದು ಪ್ರಾಕ್ಟಿಕಲ್ ಎಕ್ಸಾಂಪಲ್ ಇಲ್ಲ ಅಂದ್ರೆ ಈ ಇದ್ರ ಮೇಲೆ ನಾವು ಡಿಸ್ಕಸ್ ಈ ಅಬ್ಸರ್ವೇಷನ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಒಂದ್ಸಲ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ವಿ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡೋಕೆ ಇದು ಮಾಡಿ. Even leaving the other lady question, with PCM, AV, and ಸುದ್ದಿ ಬಿಟ್ಟು ಸಹಿತ ಈ ಬರೀ ಈ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಅವರ all that they have done is ತಾವೇ ನೋಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನ್ ಕೊಟ್ಟಿದ್ವಿ ಈಗ ಬಂದ ಕಂಪ್ಯೂಟರ್ ಮಾಡೋದೇನು ಫೀಡ್ ಮಾಡೋ ಮೇಲೆ ಫೀಡ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಇಲ್ಲ ವಾಟ್ ಶಿ ಹಸ್ ಪಾಯಿಂಟೆಡ್ ಔಟ್ ಈಸ್ ಕ್ಲಾಸ್ 4 ಅಲ್ಲಿ there is a particular direction that is issued, so it has taken into consideration that one. ಹಂಗಾಗಿ immediate previous ಏನಾಗಿದೆ ಅದನ್ನ it has taken into consideration. ಅದೇ ಅದೇ ಇಮಿಡಿಯೇಟ್ ಪ್ರೀವಿಯಸ್ ಟರ್ಮ್ ಏನು ರಿಸರ್ವೇಶನ್ ಆಗಿತ್ತು, ಇಫ್ ಇಟ್ ಇಸ್ ಗಿವನ್ ಫಾರ್ ಫೀಮೇಲ್ ದಿಸ್ ಟೈಮ್ ಇಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಗಿವನ್. ಅದನ್ನ ದಟ್ ಇಸ್ ದಿ ಆನೇಕಲ್ 22 ಹೌದು.
ಅವರಿಗೆ SC 2 ಸಲ ಬಂದಿದೆ, ರೆಗ್ಯುಲರ್ SC ವುಮನ್ 2 ಸಲ ಬಂದಿದೆ, SC ಅಂದ್ರೆ 1 ಸಲ ಬಂದಿತ್ತು, ಈಗ ಮತ್ತೆ SC ವುಮನ್ ಕೊಟ್ಟಿದ್ದಾರೆ 2ನೇ ಸಲ ಬಂದಿದೆ, ಒಂದು ರಿಸರ್ವೇಶನ್ ಬಂದಿದೆ.
ಮುಕ್ತಾನಲ್ಲೂರು ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ? ಅದೇ ಅದೇ ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಜನರಲ್ ಎಸ್ ಮೇಡಮ್. ಹೌದು. ಅಲ್ಲ, everyone are pointing out, see, please see 2015. The same reservation is given in 2015. Why are you pointing out to 2000, 2005? The requirement is there should be rotation. Why are you pointing out to something that has happened in the year 1993, 2000, 2001, 2005? Please see what has happened in the year 2015. The same reservation is being given again now. Allama, allene there was a scope for, you are trying to say that since clause 4 says you will have to take into consideration the immediate past reservation. If it is given for a lady candidate, this time it should not be given. That cannot be the only criteria. Not that entire 5 years they have enjoyed. Adala ಹೇಳ್ತಾರದು. ಅದಲ್ಲ 5 years, entire 5 years ಅದಲ್ಲ ಹೇಳ್ತಾರದು. The requirement of law is there should be rotation.
Not anyone's case here. It is not even a single unequal challenge here. In the number, nobody challenges. Nobody challenges specific guidelines. And the computer will not know the 2015 level entire file is one category and then another category. Computer can see 2020 stuff.
ಅದನ್ನೇ ಹೇಳ್ತಾರದು ಅವರು. See, that is the mistake. You will have to feed all this relevant information to the computer. The computer has to take into consideration all the past reservations. Other, see, if the application itself is faulted, if you are saying it will take into consideration the immediate past reservation and not the previous reservations, then there is something wrong. Correct. Correct.
We cannot, even if they will again detained by try to give SC even for Burden and internal. SC on the third time, SC will not get. SC has got only once. Second time, SC is coming. And for narrative.
Palluru.
General.
Hmm.
Actually, keeping in mind that the software is faulty, the guidelines are faulty. Because looking at the factors that the this may not be
that argument is made, they are pointing out that there are cases where for the third time you have given the reservation. ಅದನ್ನ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು.
guidelines. Similar guidelines.
That is why I said, since they have challenged the notification for the first time, we will not be able to do anything at this point of time. We keep this these writ petitions pending because there has to be done something in the matter of formulation of the rules. Whether the rules are in compliance of the constitutional provision is something that courts will have to see. Now that they have challenged the notification, we will consider them. And since this is only the second term, and there is a short period, we may not interfere on that ground in this election. But wherever minor discrepancies are pointed out, which can be solved by swapping, we have issued directions. We will do that. Here, since there are 6 or 7 writ petitioners challenging the reservations made in Anekal itself.
Representation itself on 23/6.
ಆಯ್ತು ಮಾಡಿ, we will keep this petition also pending to consider the challenge raised to the notification. Okay. Yes, sir. ಯಾವುದು ನಿಮ್ದೆಲ್ಲ ರಿಟ್ petitions? No, I will briefly note down all your objections. That itself will be considered by the deputy commissioner. You don't have to go and file one more objection there. ಯಾವುದು ನಿಮ್ದು ಎಲ್ಲ ರಿಟ್ petitions? Serial number? 16, 19, 13. Writ petition number 14,091 of 2023. ಇನ್ನು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ಅದೇ ಬೆಳಿಗ್ಗೆ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಆಯ್ತು. ಆಮೇಲೆ ಅಷ್ಟೇನಾ? 4 Allah, there is a larger question. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು, it is better to have reservation for BCA, BCB also. ಅದೇ. So, if directions can be given, this will be in serial number 13, 16, 19, 17, 19. ಆಮೇಲೆ ಬೆಳಿಗ್ಗೆದು ಒಂದು serial number 3. Learned Senior Counsel Sri Jaikumar S. Patil, appearing for the petitioners in WP number 14341 of 2023, has submitted that the reservation provided in Anekal Taluk has been challenged in the said writ petition, not only on the ground of violation of the basic principles of rotation in reservation, but also raising a challenge to the guidelines issued by the State Election Commission through the government order dated 25/5/2023. The Learned Senior Counsel has raised the issue regarding the guidelines not being compliant of the constitutional requirement of providing reservation in terms of Article 243D, which is also reflected in Section 44 of the Karnataka Gram Swaraj and Panchayat Raj Act. So, it is submitted that the requirement of the Constitution is what are the offices of the chairperson in the panchayats at the village or any other level shall be reserved for scheduled castes, the scheduled tribes and women in such manner as the legislature of a state may, by law provide. And the reservation shall be in proportion to the total number of such officers in the panchayats at each level as the population of the scheduled castes in the state or of the scheduled tribes in the state bears to the total population of the state. So, having regard to the provisions contained in subarticle 6 of Article 243, capital D of the Constitution, provision has been made in clause B of subsection 2 of section 44 of the Act for providing reservation to the backward classes. Full stop. However, it is submitted that the proviso to clause C of subsection 2 of section 44 makes it very clear that the offices reserved under the subsection shall be allotted by rotation to different gram panchayats. It's the top. It is therefore submitted that the rotation has to take place taking the entire state as an unit and not taluka wise, as is sought to be done in the impugned notification. Stop. Be that as it may, the immediate requirement to address the grievance of all these petitioners, writ petitioners, who have challenged the reservation made in Anekal Taluk, this court is required to issue certain directions. Stop. It has been pointed out from the impugned notification and the checklist worked out by the Deputy Commissioner, that in gram panchayats like Vyagada Denahalli, Andenahalli, Mugaluru, Nerega, etc. In the year 2015, reservation was provided to the post of Adhyakshas in all these Gram Panchayats for scheduled caste category. Stop. In the present impugned notification, again, reservation is provided to scheduled caste category. Stop. Similarly, in Ballur also, in the year 2015, reservation was provided for SC female, and this time too, reservation is provided for SC woman, SC female. Stop. Huh? Full stop. Similar is the case in Muttanalluru also. Full stop. The next para. Contentions of the learned senior counsel as well as the other learned counsels who are appearing for the writ petitioner in common is that one of the relevant factors which was required to be considered was whether in the past reservation was provided for a particular category was required to be considered. Stop. This important factor not having been considered, blame cannot be put on the computer application. Stop. It has been pointed out that in several of these constituencies which are mentioned here in above, reservation for scheduled caste category have been repeated for the third time. And similar is the case wherever reservation is given for SC female. So, on the other hand, learned additional advocate general has pointed out to clause 4 of the government order dated 25/5/2023. Uh, 25/5/2023. Clause 4 5 that the guidelines prescribe that the immediate past reservation should be taken into consideration. Stop. If the reservation in the previous past was made for a female category, then the next time reservation should be avoided for female category. Stop. And vice versa. Full stop. Next para. In the considered opinion of this court, the learned senior counsel and the other learned counsels appearing for the writ petitioners have raised a valid point that the requirement of law is to rotate the reservation. Stop. If the guidelines have prescribed that the immediate past reservation is required to be taken into consideration, that may not be sufficient. Stop. In clause 4, it has been provided. In clause 4 of the guidelines, it has been provided that the past reservations should also be taken into consideration. Stop. Therefore, the election officer cum deputy commissioner was required to take into consideration the reservations earlier provided to the constituency. Stop. If reservation was provided for a scheduled caste category in the year 2015, comma, in the year 2020, comma, at least in the second term, reservation could be provided to scheduled caste female and vice versa. Stop. This would meet the requirement of law, which provides that there shall be rotation in reservation. Stop. This important factor cannot be ignored. Stop. Next paragraph. For the reasons stated above, comma, as an interim measure, comma, it is hereby directed that the election officer cum deputy commissioner, comma, Bangalore Urban District shall rework the reservation provided in the impugned notification, bearing in mind the observations made herein above. Stop. Next para. Since there is apprehension expressed by the petitioners that the calendar of events may be announced very soon, comma, the deputy commissioner is required to rework the reservation. We will ask him to re-notify it or issue a draft only. The deputy commissioner and the deputy commissioner bar state election commission and the state election commission shall rework the reservation and issue a fresh notification on or before 14th of July, Friday. Huh? Nineteenth of July, 2023. Next para. Release this matter on 19th of July. These matters. Yes.
provided by the government of delegate. But the general female is for fifth time. Number 20.
ಎಲ್ಲಿದೆ ನೀವು ಚೆಕ್ ಲಿಸ್ಟ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
Then 24 times now. And you got me as
ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಅಲ್ಲ? ಕನ್ನಸಂದ್ರ.
According to the regulations, all the categories are SC, ST, BCM, two constituencies for the doctor. I think Chanasandra and 30 is the same number 5. They claim that these two constituencies they have adopted the process of
ಲಾಟ್ರಿ.
that is not permissible. I will find out. When we see for general female, this is the fifth time we are getting to this. So for Arti Gram Panchayat, there was no reservation to general female. How? Any point of?
ಇಲ್ಲ.
Arti general female.
2010 ಜನರಲ್ ಫೀಮೇಲ್. 2010.
Sorry.
ಹೌದು.
So far as my constituency is concerned, it is the fifth time. So immediately prior to proceeding selection, it was reserved for general female. So they had every option, not the respective subsidiaries. There was no difficulty for the election officer to reserve it to seal number 5. Constituency was always many times represented with general category.
It has been given general.
General. It is also general also many times for the months.
2015 also general.
Yes. So clause number 4 of the guidelines is not followed. Immediately preceding selection, reservation was in female only. There was no scope for taking the process of lottery. As far as possible, there was every possibility of reserving it to serial number 5. So far as general rules. That is my respect.
Why lottery was required to be taken?
Equal number of female members.
Equal
number of female members. The contention is both the panchayats has to put equal number of female members elected. That is the contention. That cannot be applied. If 4 is to be followed, clause number 5 cannot be applied. First they have to comply with clause 4 of the guidelines. Then not be considering that clause 5 will apply. Immediately, if this constituency was represented with general female, that could not have been repeated. There was every scope for to allot it to Karnataka Gram Panchayat, where the female was represented only once, and the Karnataka was represented by general more than once. Your decision to go for lottery is that.
Yes, please read that page number 44. Yes. ಅಲ್ಲ ಅದು ಗೊತ್ತಾಯ್ತು, ಬಟ್ ದಿ ಕಂಟೆನ್ಷನ್ ಈಸ್ why it was selected for lottery. ಅಲ್ಲ ಬಟ್ ಅಲ್ಲಲ್ಲ, ಫಸ್ಟ್ ರೊಟೇಷನ್ ಆಗ್ಬೇಕಲ್ಲ. ಎಲ್ಲ ಆದ್ಮೇಲೆ ಜನರಲ್ ಕ್ಯಾಟಗರಿ ಬರ್ತೀರಾ. ಜನರಲ್ ಕ್ಯಾಟಗರಿಲಿ ಆಲ್ದೋ question of picking up by lottery is definitely there. There is no difficulty about that. But when it has to be applied is the question. SC category depending on the population, the one that has got the highest will get the first reservation. In the next term, that has to be left, you will come to another one. So adara idrallu ashtene general alli you have to find out whether in the previous term their reservation was given to general women category. ಅದನ್ನ ನೀವು ನೋಡಿದಿದ್ರೆ ಅದಾಗಿಯೂ ಕೂಡ if you get 2 or 3 which are standing on the same footing, then the question of picking up lottery would come. Not straight away to consider okay. So therefore that concept of only looking to the immediate past reservation, if female is given there is easily kodabardu anta, because we have found in many such cases we have repeated it. In spite of the provision being there, still we find that even in the past, immediate past, you are given for female, this time also you are given for female. So it is not that mandatory. Correct. So therefore this contention is allala, if you had looked at the past, whether general female reservation was given, and you keep it out this time. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು, there is no difficulty. You have come to the end portion of it where you have only general to be given. Alli, if you had seen whether in the past general female reservation was given or not, if it was given, then exclude it this time. ಆಮೇಲೆ ಅದು ತಪ್ಪು ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. ಕರೆಕ್ಟ್. ಅಲ್ಲ ಅವಾಗ ಏನಾಗುತ್ತೆ, constituency that has got the highest number, so invariably it will be repeated. Then if you are not going ಅದೇ equal ಯಾವಾಗ, that is not going to change. ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಅಮ್ಮ correct. Yes. But see, but there is substance in what he is saying. ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಯಾರು ಕೇಳ್ತಾರಲ್ಲಿ ಅವಾಗ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಹೇಳ್ದಂಗೆ you think the deputy commissioner will listen to them when there is objection? There is no difficulty. We accepted your submission that if a lottery is picked up, you cannot have a grievance. There is no difficulty. No. Alli, we found substance in your argument that after fulfilling all the requirements, we found 2 or 3 categories standing on the same footing. ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ನೀವು when you come to reservation for general category, if you simply say we'll start giving it to the constituency that has got the highest number, then that is not going to change at all. Then tell Madidra, you show, you please, if that is the case, then there is no difficulty. Yes. ನೋಡಿ 43 ಅಲ್ಲಿ ಆ ಟೇಬಲ್ ಇದೆಯಲ್ಲ, ಅಲ್ಲಿ ಟೇಬಲ್ ಇದೆಯಲ್ಲ ಮೇಲ್ಗಡೆ, ಅದು SC ST ಗಳದಾಗಿತ್ತು. ಅದಾದ್ಮೇಲೆ ಜನರಲ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. ಅಲ್ಲಿಂದ ಓದಿ. ಅದಾದ್ಮೇಲೆ ಓದಿ. ಅದು ST ಇದಾಯ್ತು. ಅದು ಎಷ್ಟಿದು ಆಯ್ತು. Yes.
Then when it was not fixed for the rework, we resumed the limit. This is not something that is paid or not.
Yes.
Not really.
Yes. ಆಯ್ತು. ಕರೆಕ್ಟ್. ಅದು ಬೇಡ ನಮ್ಗೆ, ಅದು ಬೇಡ. Yes. Yes. ಅಲ್ಲೂ ಮತ್ತೆ ಚಂದ್ರಚಂದ್ರ ಬರುತ್ತೆ. ಹೌದು, ಆಯ್ತು. ಎಸ್. ಎಸ್. Andre, now he is pointing out to Harati, isn't it? Serial number 1 alle Harati ide ಮೇಲ್ಗಡೆ. ಅದ್ಬೇಡಿ, ಅದು ಅದ್ರದ್ದು ಇದ್ರದ್ದಾಯ್ತು. We are not concerned about that. Now we have come to stage of allotting this general category. ಆಯ್ತಾ? What they have said, out of 8, ನಂತರ ಈ ಪೈಕಿ 8 ಮಹಿಳಾ ಮೀಸಲಾತಿಗೆ 7 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳನ್ನು ನೇರ ಆಯ್ಕೆ ಮಾಡಿತು. ಹೆಂಗೆ? One. Andre, Harati, because previously it was SC female. ಆಯ್ತಾ? ಕೂಲೂರು. ಕೂಲೂರು 17 SC female. ಸ್ಟಾಪೂರು. ಅದೇ ಡೈರೆಕ್ಟ್ ಆಗಿ ಯಾಕೆ ಸೆಲೆಕ್ಟ್ ಮಾಡಿದ್ಯಾ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು ಅಂದ್ರೆ, ಬಿಕಾಸ್ ಇನ್ ದಿ ಇಮಿಡಿಯೇಟ್ ಪಾಸ್ಟ್ ರಿಸರ್ವೇಶನ್ ಫಾರ್ ಫೀಮೇಲ್ ಕ್ಯಾಟಗರಿ, ಸೊ ದೇರ್ ಫಾರ್ ದೇ ವರ್ ಡೈರೆಕ್ಟ್ಲಿ ಗಿವನ್ ಜನರಲ್. ದಿಸ್ ಇಸ್ yes. So what we can say is, they have not manipulated it. They have gone by what they have understood from the guidelines. Immediate past ಅಲ್ಲಿ ಫೀಮೇಲ್ ಕೊಟ್ಟಿದ್ರೆ ಈ ಸರಿ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. ಅದು ಬಿಕಾಸ್ ಆಫ್ ಲಾಟ್ರಿ. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. Your constituency also was considered. It was considered, but first 7 ಗೆ they went on giving straight away from serial number 1, which has got the highest number. ಅಲ್ಲಿಂದ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರು, 7 ಮುಗ್ದೋಯ್ತು. ಇನ್ನು ಒಂದು ಬಾಕಿ ಇತ್ತು. Both of you were standing on the same footing, so therefore they
there was no female representation. Immediately preceding the selection. Immediately preceding the selection.
SC female, sir.
General female. I am talking about general female.
No. RT is given SC now, not general female. Please understand. What they are saying is, in terms of the guideline, if immediate past it was given for a female category, this time it should not be given. So therefore, taking that into consideration, the first 9 ಇದೆಯಲ್ಲ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, they were directly given, having found that
they could have found that immediately preceding the selection, my constituency was represented by general females. But wanted them to look into this aspect of the matter. Not only once, this is 5th time. their condition of to be accepted, the respective submission is, it is a case where the visiting the selection, the general women was represented. One was, I will repeat, the confrontation is fifth time. Officer selected. Sir, this petition is accepted, but I will be putting my constitutional right. There are only item about it. It could avoid a 10 female to in the light of protection policy. Just because the limits are drawn, it can't be accepted.
ಉಳಿದ ಈ ಕೆಳಕಂಡಂತೆ 17 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳನ್ನು ಸಾಮಾನ್ಯ ವರ್ಗಕ್ಕೆ ನೇರವಾಗಿ ಆಯ್ಕೆ ಮಾಡಿತು. ಅಂದ್ರೆ 17 were to be given general reservation. That is the meaning. 17. ನಂತರ ಈ ಪೈಕಿ 8 ಮಹಿಳಾ ಮೀಸಲಾತಿಗೆ 7 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳನ್ನು ನೇರ ಆಯ್ಕೆ ಮಾಡಿತು. ಯಾಕೆ ಬೈ? ಇವ್ರದ್ದು ಅದೇನೆ. No, I think the only difference that I can find is in the numbers. They had more number than you. All the others, all of them had more numbers than you. The general category. You please see the general. Please see the. Party has got 11 general category members. 11. Party. Shahpur has got 10. 11. Shahpur has got 10. Illa.
It's for general. I'm canvassing for, and my illness is the reservation, women reservation, general women.
Correct.
Women comes without category.
Correct.
That cannot be read with
ನಿಮ್ದು 10 ಇದೆ. ನಿಮ್ದು 10 ಇದೆ. ಹೌದು.
5 equal. 30 and Chandra 5 equal.
No, out of that 10, 5 will be reserved for women. That is there. That is the constitutional requirement. So they have done that. No, I am trying to understand why that 7 were given directly and not you.
You have to filtering all those things also. When it matters for
I am not able to understand why.
When it matters for considering 30 and my constitution matters.
What is the difference? Why?
They should have taken into consideration that immediately prior to this election, general women was represented. In violation of their own guidelines. General women.
It's a little difficult to understand this sentence. ನಂತರ ಈ ಪೈಕಿ 8 ಮಹಿಳಾ ಮೀಸಲಾತಿಗೆ 7 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳನ್ನು ನೇರವಾಗಿ ಆಯ್ಕೆ ಮಾಡಿತು. ಯಾವ ಕ್ರೈಟೀರಿಯಾ ಮೇಲೆ? ಇವ್ರದ್ದು ಅದೇನೆ. ಅಲ್ಲಲ್ಲ ಅದನ್ನ ಬಿಡಿ, ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಿಡಿ. Let us understand what is it that they have followed. Let us try to understand that. Yes. Yes. ಇಲ್ಲಿ ನಾವ್ ಓದ್ಕೊಂಡು ಬಂದ್ವಲ್ಲ ಮೇಲ್ಗಡೆಯಿಂದ, we have come to a stage where 17 gram panchayats were required to be allotted general. So ಅಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೆಳಗಡೆ ನಂತರ ಈ ಪೈಕಿ 8 ಮಹಿಳಾ ಮೀಸಲಾತಿಗೆ 7 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳನ್ನು ನೇರವಾಗಿ ಆಯ್ಕೆ ಮಾಡಿತ್ತು. ಹಾ ಹಾ ಹ್ಮ್ ಹಾ 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 ಹ್ಮ್ ಲಾಸ್ಟ್ ಒನ್ ಅದು ಸೇಮ್. So commencing from serial number 10 to 16 ಅಂದ್ರೆ 7 ಆಯ್ತು ಅಲ್ಲಿಗೆ. Yes.
In the previous occasion, my constituency was represented by the MP. So that would not have been included in terms of the guidelines. First, they have to satisfy the guideline number 4. Guideline number 4 and 5. Can you go to class number 4 of the guideline?
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ. 8 reservations were to be given to general female. 8. ಒಂದು ನಿಮಿಷ. ಈಗ ಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಇವಾಗ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿರಲ್ಲ ನೀವು. 10 ರಿಂದ 16. Why Chandasandra had to pick by lottery? ಅಲ್ಲ ಒಂದು ನಿಮಿಷ. they made a list. They made a list of all those gram panchayats which were eligible for allotment of general women, commencing from Marjanahalli. Correct? 8 reservations were to be given. 8. How many are there? 1, 2, 3, 4, 5, 6, 7, 8. ಇಲ್ಲ, Chansandra was last time given general female, so therefore it would not have come in that list. That list comprises of only those gram panchayats which were earlier given general. So they were to be given general women, isn't it? Correct. So how many were eligible? Only 1, 2, 3, 4, 5, 6, 7. Only 7 were eligible for direct allotment of general woman category. One more was left. That had to be given. So they have picked up this lottery.
Currently, last paying SC premium.
Correct.
That cannot be equal to the general women.
ಅಲ್ಲಲ್ಲ ನಾವು ಎಲ್ಲ ಆದ್ಮೇಲೆ ಕೊನೆಯಲ್ಲಿ 17 ಗ್ರಾಮ ಪಂಚಾಯತ್ಸ್ ವರ್ ಲೆಫ್ಟ್ ವೇರ್ ಜನರಲ್ ರಿಸರ್ವೇಶನ್ had to be given. ಆಯ್ತಾ? ಔಟ್ ಆಫ್ ದಟ್ 17, 8 had to be first given general female. ಅಲ್ಲಿ they saw 6 of them were directly eligible because they were earlier given general, not general women. So R directly they had allotted. Then came your chance.
ಮೋಸ್ಟ್ಲಿ 10 ಗ್ರಾಮ ಪಂಚಾಯತ್ ಜನರಲ್ ಒಂದು
Huh?
ಜನರಲ್ 30 ಅದು ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್
ಇನ್ನುಳಿದ ಒಂದು ಮಹಿಳಾ ಮೀಸಲಾತಿಗೆ 2 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳನ್ನು ಪರಿಗಣಿಸಿ ಈ ಪೈಕಿ ಒಂದನ್ನು ಲಾಟರಿ ಮೂಲಕ ಆಯ್ಕೆ ಮಾಡಲು ಸೂಚಿಸಿತು. So ಚನ್ಸಂದ್ರ and ಹರಟಿ
case of case that both Bharati and Chanasandra are then female. I accept that they would have gone to the land. Category itself is different. Bharati is represented by general SC female and the Chanasandra are represented by general women.
ಇಲ್ಲ ಸರ್, ಹಂಗಲ್ಲ ಸರ್. The criteria is to allot general female category first. Aita, from amongst the 17 gram panchayats that were left, 8 were to be allotted.
What are the difficulties for them to allot it to Bharati?
Adikke
That is my mistake. If who was left out, who was represented by female SC and one the general female, if they are considering general female, they could have allotted to Bharati.
no. Both of you were stood in the same footing because previously there was a reservation for female category. It is not whether general female or SC female. That is irrelevant. The criteria is
That is not tenor of the guidelines or the use.
that is what they have followed. That is what they have followed.
May I respect to something? May I take the right of the use?
Yes. Sir. Yes. So they had to pick up lot. Yes.
The seats reserved for women in each category refer to who's one to each of state to the
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
rules. That reservation of seats in Gram Panchayat rules.
ರೂಲ್ಸ್ ಇಲ್ಲ ಅಂತಂದ್ರು ಮತ್ತೆ
In 18 ಮಾಡಿದ್ರು, I don't know if it
Huh?
repeal ಆಗಿದೆ.
ಅದೇನೆ.
Not repealed,
That is
charge
why-
is repealed.
ಅದಕ್ಕೆ ಈಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದ್ರಲ್ಲ ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಅವರು, ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಗಿವನ್ ಎನಿ ರೀಸನ್ಸ್ ವೈ ರೂಲ್ಸ್ ಆರ್ ನಾಟ್ ಫ್ರೇಮ್ಡ್.
88 rules proper ಇದೆ. I don't know. if it is-
ಐ ಡೋಂಟ್ ನೋ.
88 symbols. Guideline number 5 ಇದೆ.
ಹಾ
Yes.
ಹಾ ಎಸ್.
ಇಲ್ಲ, ಸಾಮಾನ್ಯ ಮಹಿಳೆ ವರ್ಗಕ್ಕೆ
ಅಲ್ಲಲ್ಲ, ದಟ್ ಈಸ್ ರಿಸರ್ವೇಶನ್ ಫಾರ್ ಅಲಾಟ್ಮೆಂಟ್ ಆಫ್ ಮೆಂಬರ್ಶಿಪ್ ಫಾರ್ ದಿ ಗ್ರಾಮ ಪಂಚಾಯತ್, ನಾಟ್ ಅಧ್ಯಕ್ಷ ಅಂಡ್ ಉಪಾಧ್ಯಕ್ಷ. ಇದು
objection.
ಯಾವುದು ಆ ರೂಲ್ಸ್ ಅದಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. The even learned council, senior council Jaykumar Patil was saying
Even by taking the guidelines as well.
Yes.
Guideline number 5.
ಸಾಮಾನ್ಯ
ಮಹಿಳೆ ವರ್ಗಕ್ಕೆ ಮೀಸಲಾದ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಹುದ್ದೆಗಳು ಆ ವರ್ಗದ ಅತಿ ಹೆಚ್ಚು ಸದಸ್ಯ ಸಂಖ್ಯೆ ಇರುವ ಗ್ರಾಮ ಪಂಚಾಯತ್ ನಿಗದಿಪಡಿಸುವಾಗ ಸಾಧ್ಯವಾದಷ್ಟು ಮಟ್ಟಿಗೆ ಹಿಂದಿನ ಅವಧಿಗಳಲ್ಲಿ ಈ ವರ್ಗಕ್ಕೆ ಮೀಸಲಿಸಿದ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗಳನ್ನು ಹೊರತುಪಡಿಸಿ as far as possible. In my case, it was very much possible for them to
ಇಲ್ಲ. No. Two Gram Panchayats were standing on the same footing. So they have all right. Whatever it is, we don't find that any malafides have been committed. We will accept their content. We'll have to do something further for the rules. Avag marna. Let us see that one, but not at this stage.
ಯಾವುದೇ ಮೀಸಲಿಸಿದ ವರ್ಗದ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಹುದ್ದೆಗಳನ್ನು ನಿಗದಿಪಡಿಸುವಾಗ ಒಂದು ವೇಳೆ ಸದಸ್ಯರ ಸಂಖ್ಯೆಗಳು ಸಮವಾಗಿರುವ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗಳು ಹಾಗೂ ಹಲವು ಇದ್ದು ಮೀಸಲಿಸುವ ಹುದ್ದೆಗಳಿಂದ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗಳ ಸಂಖ್ಯೆಗಳು ಕಡಿಮೆ ಇದ್ದಲ್ಲಿ ಅಂತಹ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗಳ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಹುದ್ದೆಗಳನ್ನು ಮೀಸಲಾತಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಗ್ರಾಮ ಪಂಚಾಯತ್ this is lottery. Before going into the process of lottery, they should have followed.
I was also of the same opinion. That is why I got it clarified. Why lottery anta adke kelide nanu. They have given a reasonable answer. Yes.
Had they my case clear the
direct ಮಾಡೋದಕ್ಕೆ ಬರ್ತಾ ಇರಲಿಲ್ಲ. Because no. There were 7 other Gram Panchayats which were earlier given general reservation. So therefore they were directly eligible.
If they can't repeat in those constitutions, how can they repeat in my
It is not repetition. That is why it had to be picked by lottery. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes. The petitioner is aggrieved of the reservation provided to the post of Adhyaksha of Channasandra Gram Panchayat of Kolar Taluk. Stop. Next para. Learned counsel for the petitioner submits that in the immediate past, that is in the elections of the conducted in the year 2020, reservation the post of Adhyaksha of Channasandra was allotted to general female category. Stop. This time too, the same category has been allocated to Channasandra. Stop. Therefore, it is contended that it is clearly in violation of the rule of rotation in reservation. We'll stop. Learned counsel submits that there is a constitutional mandate contained in Article 243, capital D, which is also reflected in Section 44 of the Karnataka Gram Swaraj and Panchayat Raj Act of 1993, that there shall be rotation in reservation. Stop. In other words, it is submitted that there cannot be repetition of the same category at any cost. Stop. Even otherwise, it is submitted that the post of Adhyaksha was allotted to Channasandra in the year 2000, 2005, 2010, bracketed first term, and 2020 first term. Stop. Therefore, even if the process of rotation in reservation was made by a computerized process, comma, as is sought to be contended by the learned additional advocate general, comma, these are relevant factors which were required to be considered by the system. So it was pointed out that for 30 Gram Panchayat, allotment of general category to the post of Adhyaksha was made in the year 2000 and 2015. Therefore, comma, the allotment of general bracketal female would have been made to Harati Gram Panchayat, which would meet the requirement of the policy of rotation in reservation. Stop. Next para. For contra, learned additional advocate general, comma, while pointing out to the statement of objections and the worksheet provided along with the checklist, comma, submitted, that in terms of the guidelines provided by the State Election Commission in the form of Government Order dated 25/5/2023, comma, allotment of reservation should commence from the category of scheduled castes, comma, followed by scheduled tribes, comma, followed by backward class A, then backward class B, and thereafter reservation of general bracketally female is required to be assigned. Stop. While pointing out to the worksheet, comma, it was submitted that while allotting reservation of scheduled tribe category, comma, there were 13 Gram Panchayats that were eligible, and Chansandra was one of them. Stop. When lottery was picked, the reservation went to Poluru and Muduvatti. Stop. Thereafter, even while making reservation for backward class A category, B category, once again, Channasandra was in the fray, and once again in the pick of lottery, comma, the reservation of BCA category went to Kyalanur Gram Panchayat. Stop. Thereafter, from amongst the remaining 17 Gram Panchayats, reservation of general bracket women category was to be made to 8 constituencies, 8 gram panchayats. It's all. Seven gram panchayats were directly selected since in the immediate previous past, reservation of there was no reservation of a female category to such to those 7 gram panchayats. Stop. Thereafter, the deputy commissioner was required to consider allotment of one more category of general bracketally female. Stop. The deputy commissioner found Channasandra and Harati were to be picked up for allotment of general women category. Stop. In terms of the guidelines, a lottery was picked and Channasandra was chosen for general women category. Full stop. The learned additional advocate general would therefore submit that the deputy commissioner has followed the guidelines in letter and spirit, and there cannot be any fault found in the allotment made by the deputy commissioner. Full stop. Next para. Heard the learned counsel for petitioner, the learned additional advocate general, and perused the petition papers. Stop. Although it is sought to be contended with learned counsel for petitioner that the question of picking up lottery would not arise in the present case, this court is convinced, having gone through the worksheet, that the deputy commissioner has followed the guidelines and malafides cannot be attributed to the choice of reservation. So, in fact, the learned counsel for the petitioner did not attribute any malafides to the deputy commissioner. Full stop. Next para. Having been satisfied with the allotment of reservation made by the deputy commissioner, having perused the worksheet, this court does not find any merit in the petition. Full stop. Accordingly, the writ petition stands dismissed. Huh?
That is that on the date of appointment of the arbitrator, this functioning this proceedings to issue and the proceedings not defined inside the commission of the
No time.
I mean, because sooner the matter is posted for hearing after the there was fight that matter is filed for. I think
No,
it's not listening.
No.
So,
Let it come up. Let it come up next week. We'll see. Yes, the other election matters will be listed tomorrow. We'll take it up tomorrow morning. Yes. A copy of this Order shall be furnished to the learned HCDP. No, sir. No, no, no. Oh, no, no. Sir, you have been watching how we have been working here. Not possible. No, sir. We have election matters tomorrow also. It will come up next week, sir. Please wait. Yes. It will come up next week. All other matters which have not reached today will be listed next week. Wherever interim orders have to be extended, if you mention it will be extended. Yes. The election matters nala repeat mabudu. Different list.
Court officer? Court officer? Court officer? No, they are muted. Serial number 35 points. Interim order may be extended.
Continue, sir.
Three matters. Is
3 minutes to continue, sir.
Thank you.